of list dated 7th of July 2005 is a Christian minority institution school where an approval is pending before the district inspector of schools. Approval is withheld only on the ground that in the newspaper advertisement mobile number has not been given, which is not a mandatory. Can Lordship believe it? For this one, approval is withheld. I have filed a writ petition. It is opposition has been, direction has been for opposition reply is over.
Where is notice?
Hey, this is a notice. Upon notice.
My lord, may I have your lordship's kind leave to mention, my lord, for inclusion of the hearing upon notice.
Okay, may. Okay, 1 minute.
But may I have your lordship's leave to mention, my lord? Your lordship had fixed this matter, that matter, on the 18th of August. Mr. Indranil is appearing. Lordship had heard it. I was supposed to give reply on 18th at 2 p.m. But I have spoken to them on the 18th. I will have some difficulty. It can be any day earlier also.
On that day, you
On
pray
that
for
day,
adjournment.
if I do not, it will be embarrassment. Lordship has fixed it at 2 p.m. But if I somehow do not reach, well, it will be an embarrassment.
Okay, এটা আপনি মাথায় রেখে দেবেন। You send your junior on that date, then it will be.
May I pray for lordship's leave to mention this matter? Now, this is 127 of your lordship's list. Is figuring today. The difficulty is this. Herein, we are hostel mess workers who have been already approved by the court, put on test before the division, succeeded, retested before the Supreme, succeeded. When in spite of not being approved as a hostel mess worker, contempt is pending, they put a notice pushed by the students union to thrash us out. That has also been put on hold by the court. Even there, we are not being allowed to enter the college premises, and also we are without salaries for last 5 months. Can you imagine, lordship? Persons who have been given appointment by the court itself, approved by the court. Nothing has been done. But any day at 10:30, lordship, kindly be there without food.
Not that it would be upgraded. Upgraded. It upgrade.
Hey, we are,
Okay, in this, serially in this.
only one thing. Kindly place it on top there without food. Only, I'll take only 2 minutes.
Okay, it would be upgraded, then it would.
Okay.
May I be permitted to mention for inclusion?
What is that?
Hearing. Urgency not getting pension.
Pension matter.
Yes.
So after the heading pension matter. Coming, it is side, I am.
My lord, may I mention one matter? This is item number 476 in your lordship's combined list. But this is relating to regularization of a municipal employee. He is working for last 30 years on the basis of the interview and all selection process maintained. But unfortunately, and the municipality has written to the government that you please do it. Government said we are looking it, but nobody is taking any care. I have filed previous writ petition. The Honorable Justice, I forget the name.
Exchange of affidavit complete.
While an exchange of affidavit direction was given, no affidavit has been given.
Another order for extension. They will come.
This was the earlier order was the last chance.
এটা আপডেট করে দেখুন।
May I have my lord's kind leave to mention monthly list item number 433, my lord. My lord, the urgency is that I am the private respondent. My post is not getting permanent because of the pendency of this writ petition. My lord, the petitioner has alleged that he is eligible for the post as an additional teacher, but I have already been appointed, my lord. But it is not getting permanent because of the pendency.
You are doing job.
Yes, my lord. I am the
Getting
private.
salary.
Yes, but my lord,
You are
my
also
post
getting
is my
salary.
it's a
Wait for some time.
my lord,
I have
kindly
been
update
told
it, my
wait
lord,
for
any day, and
some
my lord,
Wait,
any
you are
day, my
getting
lord.
salary. Yes. Listed motion. Motion
But
give
we
the
are suffering, my lord. My post is not getting
motion
permanent, my
give the
lord.
slip. 1 minute. Motion. Pension matter. Okay, pension matter. Pension matter লিখে নিন। Motion. Motion. Restoration application take the application. Your motion. Motion give the slip. 126 it will reach. It will reach. Wait for some time. No. What is the urgency? Okay, senior citizen matter. Now, I'm coming. Pension matter, under the heading pension matter.
May I be?
I'm waiting for opposing. I have to oppose the mention.
May I be permitted mentioning it's a short matter. I buy a flat from Malad, took a loan from the LIC housing. Malad, that registered deed not in me. I have entire money has been paid by the repaid. Malad, that original deed, Malad, registered deed could not.
Has not returned to you.
Yes, only short matter.
What is the
signed-
ground? Why they have refused to return?
Malad, they saying that registered document.
Stamp duty
not-
has four.
No. That registered document, Malad, it has not trace out and it has lost. Malad, if lost, they give a duplicate deed from the registry of. This is my innocuous fear. Malad, let it be forwarded any day. Your lordship disposed of this matter. It's a short matter. They also agreed that.
Motion or
No, for hearing. Any day for orders, it will be disposed of. That
to be
is-
mentioned?
My lord,
To be
This is a
mentioned.
senior citizen matter, hearing matter, 2016 matter. Paperwork, everything has been completed. The petition is not being able to sell off the property due to the embargo by HITCO, your lordship.
Embargo by?
HITCO. There is a complex where the HITCO says you cannot sell off the asset. 2016 paper book is done, your lordship. Only hearing, I mean, praying for inclusion in the list.
Yeah, unless that embargo is lifted.
That is
How?
the matter of challenge, your lordship. That is the matter of challenge the writ petition. 2016 writ petition is senior citizen matter, your lordship.
Wait for some time. How
Your
many
lordship,
many
senior-
senior
your
citizen
lordship,
matter are
only
there?
The
How
petitioner
many?
wants to move out of.
Wait, you are just want to sell out. You are just want
Your
to
lordship,
sell
the
out. The
petitioner is
people
a
are
senior
left-
citizen residing out of Kolkata. He wants the money for his medical need, everything, but this is not being able to done.
All medical.
Only
When the
in-
matter was filed?
2016, your lordship. Paper books,
2016. So
everything has been completed, only inclusion in the list, your lordship.
you
Let
want to just sell out your property.
my lord,
Yes, your lordship, because there's a medical need for that. 2016 or 2025 is a senior citizen matter. I'm
All
only
are
paying for inclusion in the
senior
list.
citizen matter and all are medical emergency.
I can prove with the documents, your lordship. Only inclusion in the list, your lordship.
my lord, this is a
I have heard you wait for some time. I will not flee from your court. Okay.
my lord, we do family pension hearing.
Pension matter. You are getting something. You wait for some time. You. Motion or hearing? Motion. Application. So application under the heading application.
Yeah, I'm
Huh?
proceeded back. I will appeal for getting, but they not giving copy to me. I'm the petitioner.
You filed vacating application. Why have you not served?
Yes, give me a copy of the application. Yeah, that is true, but you give me a copy of the application.
For some time, it should be included. Don't worry. Wait for some time. Yes. Application letter.
Not getting my lord response.
For not getting
My lord,
ration.
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 My lord, pick it up, my lord. Now every day, my lord, phone, my lord, I am taking phone.
That it is your client. How you will deal with your client?
My lord, what needs, my lord, to be
Since they is calling every day,
to be mentioned, my lord.
the matter urgent. No.
To be mentioned, if I not entitled, then my lord.
To be mentioned matter only can be fixed.
Getting my pension, ration.
Ration. Upon notice, you have a mention.
Yes, my lord, I am give notice, my lord.
No.
Today, my lord, I am no notice, my lord. Suppose Sodhikari is the
No, without notice, no mention is entertained.
But I was challenging a transfer order, my lord, issued by the chairman of the district primary school council. Now, my lord, the division bench has held that the chairman my lord, in its on his own, cannot issue a transfer order. My lord, kindly, my lord, I was praying for inclusion of the list and hearing of
Have
this.
you joined to the transfer post?
No, 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 no.
So for hearing,
But upon
My lord,
notice,
my lord, the
yes,
matter was mentioned on the previous Thursday, my lord, and my lord was allowed the mentioning.
what is the
My lord, this is
urgency?
for extension of interim order, which is about,
Extension of interim order give, when it will expire?
my lord, it will expire on the 31st of July of the
So
31st
already expired.
July.
No, July. তার আগে দিয়ে দেবে। হ্যাঁ।
My lord, may fixes a date, my lord.
My lord, inclusion in the list.
Why
This is
application?
service benefit matter. Service benefit matter.
Application.
Application.
What application?
My lord, this is the service benefit matter.
What application you have filed?
Read petitioner has been died. The legal heirs of the petitioner made an application for substitution.
Application of substitution. What is your matter? Why are you?
2022 matter, my lord. I am.
Maybe we are
Yes,
2000.
my lord, but
I have a determination from 2016 and onward.
Yes, my
That
lord.
means there are 2016 matters.
Yes, my lord.
Court acknowledged.
Yes, my
So,
lord. But my lord,
many matters are
not
there.
getting permanent, my lord, because of the pendency of this writ petition, my lord. The petitioners are not taking.
Everyone thinks that my matter is urgent. You have to think that except your matter, there are many matters. So you are seeking now by mentioning precedent over other matters.
My lord,
So your matter is to be so urgent that preference should be given over other matters.
my lord, since 2022, my post is not getting permanent because of the pendency of this writ petition. The petition.
Okay, you are working. You will one day permanent can be given retrospectively.
Yes, my lord.
So what is the urgency? Extension of interim order, give the see when it will expire. Huh? So already expired. So it would be reinstated. We are not so vigilant litigant. You file an application for reinstatement. Huh? You file an application for reinstatement. Which application? Application for? The application is misconceived and dismissed because if there is no interim order, that cannot be extended. What is the pair of your application? If interim order is not alive, can it be extended? Under the heading application.
Lord, may I have your lordship's kind?
Huh? Why it would be upgraded? You take instruction, then come. Why? Why? Many matters are pending. So why, keeping other matter aside, why your matter will be upgraded? Compassionate appointment. Wait for some time. Yes.
Mentioning one matter, my lord, for upgradation. My matter is appearing in item 447 in the monthly list, my lord. The urgency is that, my lord, I am the senior most teacher in the school.
Huh?
I am the senior most teacher in a high school, my lord. For the last 1.5 years, my lord, the school has given appointment the junior most teacher of my school as the teacher in charge of said school, my lord. I have moved this honorable court, my lord, 2024 before my lord Shogota Bhattacharya. My lord, there was direction for opposition and reply, my lord. In spite to expire more than 1 year, my lord, no opposition has been served upon us.
Again, it is not ready for hearing.
Extreme urgent, my lord.
It is not ready for hearing.
That is so, my lord.
It is urgent according to you.
Because the junior most teacher is serving, my lord. I am the senior most.
Don't argue with the court.
Settled issue.
Don't argue with the court. Wait for some time here.
Milord, what has happened, Milord, college authorities, Milord, have retained the original academic documents of the student, Milord. Milord, in absence of those documents, Milord, I am unable to pursue my career as well as, Milord, I am unable to take part in my, Milord, postgraduate courses, Milord. Milord, since 1 year, Milord,
Why they have withheld?
Milord, because, Milord, they have made me executed a bond, Milord, where, Milord, there is nowhere mentioned regarding the retention of documents, Milord. Despite that, Milord, they have retained the documents, Milord. Affidavits were exchanged by and between the parties, Milord. Milord, these requests to be hard on merit, Milord. Man, Milord, kindly be disposed of.
Okay, wait for some time.
No, Milord, Milord, what
Wait
is
for some time.
Milord,
It
what is the
not so
difficulty? I'll
urgent.
tell your
Yes,
lordship, Milord. Milord, what is the difficulty?
Only extreme urgent matter you to.
This is extreme urgent matter, Milord.
I have.
Milord, I have participated in need MDS. Milord.
Okay,
Milord,
so
only
much time
counseling is,
cannot be.
Milord, counseling process is going on.
Will you
Milord.
stop?
Your Lordship, for hearing, petitioner is senior citizenship, Lordship is retirement benefit, Lordship.
Huh?
Retirement benefit, Lordship.
Yeah, pension matter.
My lord had fixed my matter today at 2 p.m. under the heading specially fixed matter by way of order. However, for
Why?
my lordship, this is for
What is the matter? What is the urgency?
my lordship. This is for the execution of my of the order of the that has been passed in my favor in the writ petition, asking the state to give to me 100 odd crores. My lord, had heard my learned senior advocate on the last occasion. It was directed to be fixed today.
Who is senior advocate?
Mr. Banerjee, Mr. Ratanko Banerjee, my lordship. It had been directed to be listed today. For some reason, it's not in the list, my lord.
When it was directed to?
My lordship, 30th June. I have the order, my lord.
Huh?
By way of the order of 30th June, my lord. I have the order.
30th June?
30th June. It was directed to be fixed today under specially fixed matters at 2 p.m. However, for some reason, it's not in the list, my lord. My lord, I'm praying it may be fixed in this week or the upcoming week.
Appellate side?
Yes, my lordship. It may be fixed in this week or the upcoming week per my
lord. No, returnable hearing it. Yes. State government, railway, national highway. Hearing in listed is hearing list. Hearing it. Yes.
My lord, I am mentioning an urgent matter heard by the Honorable Justice Arinda Mukherjee, and already affidavit of exchange already done, exception report already made. My lord, serve the notice upon the.
What is the urgency? You go on.
Retired benefit of the
story of carriage of proceedings.
Retirement benefit of the retired employees, with now they're suffering from old age disease.
As a pension matter under the heading pension matter.
Lordship, 21st May, my lord, your lordship was pleased to pass direction for affidavit, my lord, directing the respondent to file affidavit after 2 weeks out of vacation. Till date, my lord, no affidavit has.
Another extension of order passed. It is not ready for hearing. It is not ready for hearing. Don't use the court to force them to file their affidavit. Okay. Ready for hearing, mention the ready for hearing.
Lordship, item number 668 to 672 in the combined list of Lordship. I am praying for mentioning Lordship for the extension of interim order. Is interim order will be expired on 31st July, Lordship.
Extension of interim order.
5 matters.
The other side,
it should be taken up. Don't worry.
The thing is that I have got in a lottery a stall. That stall was granted upon me, but till date they are not handing over to me because of they want money. For allotment of the stall, I have got in a lottery a stall. That stall was allotted to me, but the position is not being given. Only the issues.
Have you given notice?
Yes, it is that matter.
Now, today you will mention that notice?
No, because that is I will inform. I know who is appearing. I know I have informed him. So weak Nandi is appearing.
Hearing matter.
No affidavit. Till date, no affidavit. Nothing. They don't bother. They are saying let it pending.
One for inclusion and 2 for upgrades. Kindly take a.
No. Why I shall include and why I shall upgrade?
Well, illegally, the private respondent appointed, my lord, as Asakonmi, my lord, challenging that illegalities, my lord, a writ petition has been filed, opposition reply has been completed, my lord. Kindly, my
For
lord.
hearing রেখে দিন তারপরে for hearing upgradation not
This is inclusion.
the include certainly upgradation take it. No, not upgradation for letter. আচ্ছা আমি এবার call the list.
Item number 1. My lord, item number 1, I am for the respondent number 5 and 6.
For the respondent number 1 and 2.
Thank you, yes.
Hearing for the petitioner, my lord.
Yes. What is the matter?
This matter relates to a compensation which was awarded by the West Bengal Clinical Establishment Regulatory Commission.
Oh.
The petitioner is seeking enhancement of the same.
The basis of your lordship direction on the last occasion to serve the copy to the parties. Even then, my lord, respondent number 5 has not been served. Although I am appearing because 5 and 6 almost same.
Have you received the writ petition?
I have received the copy. In fact, regarding the copy of the writ petition, that was 2022. Now, question only intimation was given by letter, no copy was served. And now we have checked the record that respondent number 6 has been given by some way in the year 2022, but respondent number 5 has not been given.
My lord, respondent number 5 is the hospital. My lord, respondent number 5 is the hospital, 6 is the managing director. If my lord directs, we will serve again.
Direction, when my lordship direction to serve the copy, why you are not? But I have downloaded this. Anyway, my petitioner grievances regarding enhancement of the amount given by the regulatory commission. And initially he paid for 1 lakh, that is 1 lakh 50, which has been considered as a discount, not against compensation. And now your lordship 1 lakh to 55 lakhs, as because he has come to the honorable court. That's why.
Okay, it is his petition. Allow him to place.
Yes.
Yes.
My lord, in this matter, my lord might be able to recollect. My lord, this matter, the patient concerned was admitted at Sheba Magnum Hospital. This is respondent number 5 and 6. The patient was admitted after an episode of cerebral stroke. Now, on 25th, it was detected that this patient has suffered a neck femur fracture while he was there.
Cerebral stroke, 1 minute.
Yes.
You are using medical term.
Yes.
Then
cerebral stroke, he was admitted on 21st August 2022.
On
21st August 2021. I'm sorry.
2021. Yes.
Yes. Now, thereafter, during his stay in the hospital on 25th August, an X-ray was done, which led to the conclusion this patient has suffered a neck femur fracture, a fracture in the femur bone. Thereafter, on 29th, the operation was done. And he was ultimately released on 4th of September, 11th of September 2021. The grievance of the petitioner is that the patient had suffered a fracture while under the care of the hospital. This has been admitted by the hospital before the commission. The patient also suffered bed sores during his stay under the care of the hospital. Now, initially, it was an episode of cerebral stroke. I was told that you will be incurring an expenditure of 80 to 90,000. Thereafter, treatment will be administered and you will be free to go. Now, my lord kindly sees on 22nd, the doctor kindly comes to page 76 of the writ petition. This is the order sheet of the commission, my lord.
Yes.
My lord kindly sees the first line. On 22nd August 2021, while on round, Dr. Biswas noticed swelling at femur neck over the hip joint left side. According to Dr. Biswas, who is present online, portion was paralytic because of cerebral stroke. X-ray was done on 25th August 2021. And ultimately, the operation was done on 29th August.
My lord, first of all, I question this delay as to why this delay took place in conducting the surgery when the fracture was detected on 25th. Even then, the doctor who noticed the swelling noticed it on 22nd. So 3 days after noticing the swelling, he did an X-ray. Thereafter, 4 days went by, then they did the surgery. Now, I have tried to explain this delay in my complaint. This delay appears to have been because I was asked to pay a sum of rupees 50,000 for the operation. My lord, kindly comes to the complaint at page 16.
15:15.
16, my lord.
16.
Yes.
Yes.
My lord, kindly sees the second paragraph. On 27th August 2021, the hospital authority told us that Dr. Amit Guho and his team will not charge doctor's fee for the operation. But we have to pay around 50,000 for the said operation and an additional rupees 3,000 for units of blood. If we deposit the amount on Saturday, that is 28th, then only they will perform the operation on 29th. Now, my lord, the fact that I had deposited 50,000 on 28th is substantiated from their own bill annexed at page 41 of the writ petition. My lord, kindly sees the heading advance receipt.
Yes.
On the bottom left, advance receipt.
Yes.
Now, kindly sees the date, my lord, 28th August. It starts serially from 21st, 23rd, 25th. Below advance receipt, my lord, on the left, the dates are mentioned.
Yes.
Now, my lord, kindly sees 28th August, by cash, I paid 26,000. And 28th August, by card, I paid 24,000. So 50,000 only when I deposited on 28th, they did the operation on 29th. Otherwise, God knows for how long the patient would have been kept like this. My question is, he suffered a fracture while in your care, which you have admitted. Thereafter, because of the delay in the surgery, there were repercussions. I was relegated to a wheelchair. My quality of life was got deteriorated because of your lack of care and deficiency of service. I also suffered bed sores. My lord, bed sore is something that can be easily avoided had there been proper care. But this shows that proper care was not taken by the concerned medical institution. And hence, this compensation of 1 lakh, this discount that has been offered by the commission, kindly sees page 77, considering the backdrop, interest of justice would be subserved. The second last para. If we direct payment of further discount to the extent of rupees 1 lakh, the initial cost estimated by the hospital was 80 to 90,000. My total bill came up to about 4,26,000. Thereafter, the commission gave a 1 lakh rupee discount, and they have paid that. On instructions, I say that they have paid that. But this expenditure would not have been incurred had there been proper care taken by the hospital, number one. Number two is that the question will remain that whether, if the fracture was detected in time, the X-ray was done on time, and the operation was done a little more swiftly, maybe the prognosis could have been better. Today, my lord, kindly sees the reply given by the doctor to the complaint that was filed. Kindly sees the reply that has been given by the doctor. Kindly comes to page 73.
Yes.
Kindly comes to third paragraph.
Yes.
On 22nd August 2021, morning, round the history from night attendants and staff found that whole night he was restless and trying to get down from bed on his own, though all the staff tried to prevent. I, Dr. Kartik Bishwas, in charge of critical care unit, during round detected that there is a swelling. So they admit 22nd they detected this swelling in the femoral. Immediately X-ray was done. So if we accept the doctor's version in the reply annexed at page 73, the responsibility of the hospital and the deficiency in service is aggravated. Because they did because the if the doctor claims that the X-ray was done on the same day when the swelling was detected, then after 9 days the operation was done. Admittedly, this version differs from the version before the commission, because before the commission, the doctor has stated that 22nd we detected the swelling, 25th we did the X-ray. Now, my lord, my humble submission is whenever a patient is admitted at a hospital, my lord, there is a legitimate expectation that the hospital will take good care of that patient. Now, whether he fell off from the bed or whether he was restless and because of that restlessness he tried to leave the bed, hence the fracture occurred, whatever it might be, my lord, there is no answer as regards the fact that on 22nd, after detection of the fracture, very little was done to mitigate any future harm that might be caused because of delay in surgery. In light of such fact, my lord, the consolation that the hospital did not charge doctor's fee, that may be out of some sort of penance, because they realize their mistake. But what about my loss of quality of life? So today, if I submit that because of the
now
process,
still you are
now the patient has passed away. The patient has passed away. Now, I cannot say that the death occurred due to their fault. That I will not say. But the fact remains that after
that you are forced to use a wheelchair.
Yes, kindly seize my complaint. The page 13, my lord. Kindly seize. As per the procedure of the commission, these allegations are verified. These complaints, they are required to be verified. So, kindly seize paragraph 20. Point number 20, gist of the complaint. Patient had a cerebral attack on 21st August and he was admitted in Sheba Magnum PPL hospital on the same date. He walked on his feet in the hospital. Due to negligence of hospital, his right hip joint bone fractured. On 29th August, the fracture was operated and patient was discharged on 11th September with sores in hands and lower back. Till date, the patient is in bedridden condition and is not able to walk. This was my post-operative condition.
What was their total bill, rupees? 4 lakhs?
Total bill was 4 lakh 15,069 rupees.
69?
Yes, 4 lakh 15,069. Now they had given a, my lord, this will appear from page 41. They have given me a discount of 53,000. I had initially paid 3,62,000. My grand total was 4,16,059. So the payable amount was 53,000. They have not taken that money from me. But this does not take into account the fact that because of this fracture and because of the extensive care that had to be undertaken because of this fracture, my hospital bill got inflated. I was initially supposed to remain in the hospital for 10 days. I eventually remained for much more than that.
Okay, now your grievances is the quantification of the compensation.
Yes.
Main grievances. So what is the guideline? How it would be quantified?
The commonly followed principle is that the person must be restituted to his initial state. Now, my lord, expenditure was incurred by the petitioner. My lord, at least the amount.
No, restitution in respect of physical loss of physical ability can be done. In the circumstances, it should be quantified in terms of money.
Yes.
Now, what money would be the appropriate? What is the guideline? What is meant by legal expert? Now you are asking a legal expert to quantify the compensation which is required to be awarded to the person who suffered due to deficiency of service by a hospital.
Yes.
That means some medical knowledge is required. Whether the legislation or any statute has give a guideline has given a guideline. How the compensation would be quantified.
My lord, in this,
Normally, court is asked, assign the duties in land acquisition matter and in motor accident claim case to quantify the sum compensation. But a guideline has been given to us. Which amount would be appropriate?
and at least the excess amount that was paid by me because of the extended hospitalization should be given back to me. The excess expenditure which I incurred, hospital said that I was supposed to incur 80,000. I ended up incurring 4,16,000. At least that amount should be restituted.
Whether they issued any written document that 80,000 would be the proposed cost. No. It is oral.
Oral. Verbally, the hospital
Verbally,
assured.
you are stated.
Yes.
Subject to lordship section 38 of the Act provides, section 38, clause 9. Maximum 5 lakhs.
50 lakh, that is correct.
If not exceeding 50 lakhs, sorry, 50 lakh, not exceeding 50
that is different.
50 lakhs.
50 lakhs.
Yes.
Now the issue subject to the lordships can sanction.
Whether any rule has not said anything.
A rule is silent to that effect because the power has been given to the commission. They will adjudicate because there is a body constituted under the commission that who are the experts therein. If there is a case of a surgery, then there must be a surgeon who is the expert in this field.
Yes, expert.
And he adjudicates this. And if your lordship kindly sees the order passed by the authority, but that is, Lord, at page, Lord, it will appear that Honorable Chairperson, Lord, this is
page
78.
78.
Yes. Lord, Honorable Chairperson. Lord has got it.
Honorable Chairperson.
Thereafter, Lord, Dr. Sukumar Mukherjee, Dr. Madhusudan Banerjee. Thereafter, Dr. Maitri Banerjee and Srimati Madhavi Das. Lord, these are the constituted committee when the complaint was adjudicated.
But the commission has abruptly jumped to the conclusion that here 1 lakh. Why 1 lakh? Why not is 50,000? Why not 3 lakh?
My lord,
That reason. That reason should be given.
That has not been given, but the.
So I am sending them back to what can be done. I am relegating the issue that quantification not properly and no reason behind it.
No, Lord, probably he has received the.
My lord, apart from
awarded money he has received.
No. No. He has not received because he has not given the details. So, on the contrary, he has challenged this before this honorable court. My lord, also kindly see the first para of the order. Kindly see, page 75. The complainant would raise serious issue with regard to the treatment protocol that would be outside our dominion. Outside our dominion, however, the part that would relate to the hospital negligence, we wish to examine this end.
Exactly.
Kindly see, thereafter, my lord.
Because the doctor's part, the commission has got no authority to adjudicate the same. But the negligence part on the particular hospital in question, that can be done.
My lord, thereafter, my lord.
Learned Council, you have not challenged the order of the commission. You have not challenged.
No, we are.
So here, petitioner challenge is confined to or limited to the quantification of compensation.
There is scope, my lord, review. There is a scope of review.
Problem.
Yes, my lord. Yes. No.
Apply your mind.
No, yes.
If you don't challenge the order, that you are not permitted to question the legality of the order. Now he is aggrieved with the quantification part. He has not challenged that the other portion of the order. So quantification. Now you confined your submission that the quantification is justified.
Yes.
Okay. Except this, you cannot raise any other point. The quantification is justified.
Exactly.
You just
Exactly.
submit the
Exactly. Ma'am. Kindly see page 76.
76.
Page
Yes. You
last one from the top, my lord, fifth line. The medical board was constituted. Medical board was constituted taking an orthopedic surgeon into confidence. Surgery was conducted. CE did not specifically charge for the procedure yet. The patient had to be admitted till September 11, 2021, involving the huge treatment cost to the extent of 4 lakhs. Even after giving discount, rupees 53,669, the patient party had to pay 52,562. The complainant would contend the patient had no proper means to pay. Treatment would be done with support from the relatives, and he is not yet fully cured. Dr. Bisa, I'll kindly see thereafter, my lord. Thereafter, my lord, kindly page 77, page second para.
No, please continue with the reading. Dr.
Kindly see.
While confronting the allegation
that complainant with fairly admitted the fracture could be located through X-ray on 25th August 2021 while the patient was under treatment at the CE.
Yes.
And they conducted the surgery and did not charge for the same.
Maybe.
Did not charge
Due
the
to their
same.
latches, it has been done for such reason. They have,
this is the
they have
question.
realized it that
No.
What we have suffered.
It can be
C means
clinical establishment.
Legal establishment. But kindly see, my lord, thereafter the complainant would also raise issue of bed show that he also, Dr. Biswas, would fairly admit, however, he is not in a position to give any possible explanation for the same, and explanation offered by him does not impress us. Impress us. Kindly see next. The complainant would demand compensation. Alleging hospital negligence, we have carefully considered the issue. Fracture was located during the stay at the CE. Though we are not sure about hospital negligence, we feel the hospital should take responsibility for the same, and in fact, they have done so by not charging for their orthopedic surgery. And the hospital stay has been prolonged to a substantial extent, hence the excess bill. Considering the backdrop of the interest of justice, we assert if we direct payment for further discount to the extent of rupees 1 lakh, the complainant would contend it should be 1,50,000, enhanced to 1,50,000. We do not find any reason for the same. Thereafter, my lord, she was given opportunity to pay the amount 10 installment.
What was your cost for the treatment of cerebral episode? Cerebral, what was your cost? And after how many days you have to discharge him?
Well, in this regard, then instruction is referred because categorically effective. Categorically
yes,
effective.
absolutely.
They will pay that part.
The patient usually it is taken into an ICCU or CCU. But the structure of the bed, whatever according to my experience, I have seen in respect of my father that there is a barrier. Nobody can jump upon it, from it. There is a barrier. Now they are saying the patient is trying to jump. That is impossible thing.
No, that means you are left without any care.
Exactly.
And he is fall. How one patient will fall up from the bed.
To take care.
That is your negligence. Your negligence. You left the patient unattended for a considerable period of time.
But
during that period of time, at that time, what sort of reaction a patient can show, doctor will say. But since his time, that means He was feeling uneasy then. And he is not, he is want to change, he is trying to change the atmosphere. And he's, then the incident occurred. He fell down. You left unattended. There was none.
But there is no, in the observation, my lord, in the order.
Their observation
But
is not
first of all, my
conclusive.
lord, he was admitted.
Their observation is not
My
conclusive.
lord, he was admitted with.
Okay, what can be done? One thing, you can file a report. Yeah, how much
No,
was your
subject to lordship's kind sanction? Just now, what I have heard from my learned friend that he is willing to play 1 lakh. That is according to the award passed by. But now the prayer, if your lordship kindly sees by the complainant before the authority, that was 1.5 lakh. Let that be considered between them. If it is enhanced to 1.5 lakh, I believe, my lord, there will be no harm.
No, what was the cost of the treatment up to the cerebral episode?
So that is up to the, you will get from here.
What is that? হ্যাঁ
আরে এই তো আছে
আরে কি করে তুমি এখান থেকে বলে দেবে ফটাফট তুমি আগে
পেজ মিস্টার
কত পেজ হচ্ছে 24
The bills, my lord, they are annexed from page 36. Sorry, man. Starts from way back.
Look, page 40, doctor consultancy on 21st August to 21st August to
11th September.
7th September. You are discharged on
11th September.
11th September.
For admission in this hospital, my lord.
Paid charge according to them, it shows 1,10,000. Paid charge only. According to their bill, page 24.
Yes.
Oh.
That means he was in ICU. And it's a critical unit. There must be an attendant. For 24 hours. That was not there.
বুঝালে কি করে ছিল না আইসিইউ তে 24 আওয়ার
তাহলে পড়লো কি করে তোমরাই তো বলছো হ্যাঁ
পড়ে গেছে কি তো my lord it is my lord he was admitted the cerebral attack before his admission he was admitted in the another 2 hospital. Yes, he was also admitted, my lord. Kindly either it is affidavit is record or review is there.
So when it was detected, the fracture when detected?
Fracture was detected on 25th, but the swelling was detected on 22nd. Swelling detected on 22nd. X-ray done 3 days later.
He was admitted on
21st. 21st. So, my lord, the intervening night of 21st and 22nd, this occurred. The fracture occurred.
Initially, when he was discharged, had this incident not occurred?
My lord, if from that is written in the complaint. Kindly comes to page 15.
Page 15.
15.
16.
No, my lord, 15, my lord, 15.
Yes.
Kindly sees the first paragraph, but the line is first, second, third, fourth, fifth, sixth, seventh, 8, 9, 10, 11, 12th line, my lord, 12th line. We checked with Dr. Dotto on expenses. Has my lord found it? It starts from the middle. We checked with Dr. Dotto.
Yes.
On expenses. He further checked it with Dr. Kartik Vishwas, Chairman and Managing Director, over phone, and informed us patient will need 4 days of ICU and 3-4 days of general bed hospitalization. And after that, he will be released, and total expenses will be 8,000 to 10,000 per day in ICU bed, 4,000 to 5,000 per day during his stay in the general bed.
So I'm referring them to quantify.
You're taking into consideration the
Every day, all these factors, they will quantify or assess the compensation afresh. That would be better. Agent petition has been prepared. You are the petitioner. One minute, I'm coming to you. Want the authority to make a whole payment of outstanding dues of the petitioner for the period as per 6 RA. Running bill and final bill submitted the petitioner including security money and earnest money. Yes, the petitioner is a contractor.
Number kindly comes to one page 27. That is the order of this honorable High Court.
That means for maintenance of PG railway track from Mejia Thermal Power Station to Raniganj connection. It was the contract.
Number kindly comes to page 27. That is the order of High Court.
Yes.
Now your lordship will find whether they decide on what. Second para, the writ petitioner is the contractor rendering service to Valley Corporation under the Contractor Regulation and Application Act 1970. Read with the part. A principal employer is liable for any unpaid or unpaid wages to the contractor. This is another Valley Corporation evidencing these payments they have made the business payment. That was not the whole class because the slips which are paid for the EPF organization that was not placed on this. Now, under the circumstances, the petitioner will have to satisfy the amount of value contribution by project. They have to pay our payment to the part authority and EPF. If the originals are lost, the petitioners may rely on properly authentic copies of the documents by the provident part authority. So, may also be relied on. The respondent number 2 will go into the issue. After allowing the parties to and pass a resolution with the of communication of this order, the provident fund authority is directed to render cooperation. Thereafter, they authority kindly comes to page
30.
31.
31, yes.
31. Let me agree for the second part. Based on the submission made and documents furnished by CC during the course of personal hearing, in court, that payment has been paid to provided on authority and the employee by CC for the state work given that from increased value connection with the captive railway system including waiting loops, siding, plus negative area siding lies inside the plant area of and other allied works. Moreover, no complaint and demand from any corner was received by NTPS authority either in RO non-compliance or of create provision or regarding non-payment of wages of concerned workers during the relevant period. Therefore, controls set by the Contractor 1/8/2017 passed by the Honorable High Court, Calcutta, suggests that and based
I am of the view MTPS shall not withhold the payment of outstanding dues of Sri Ram Sakal for the period of such and such. Apart from
not only that, the earnest money, the earnest money is that is also pending. Security money, that is also pending.
Well, may I just humbly submit, this writ petition is coming and appearing before your lordship for the first time. If your lordship kindly directs us, my lord, to use an affidavit, because my lord, whether these disputed bills of my lord 2022, my lord, I need to take instruction with regard to my lord, by way of by way of this writ petition, basically, my lord, money claim has been my lord made before this honorable court. Now, my lord, I need to check whether the RA bills are disputed one or not.
This is number one. Number two, my lord, only my lord, the last but one paragraph has been shown to your lordship. But my lord, the last paragraph your lordship kindly sees. My lord, the authority concerned has also, my lord, directed that, my lord, the MTPS, my lord, the second line, the DVC officials of MTPS must satisfy itself regarding observations, adherence of other rules, regulations, and terms and conditions of the work as stated in the work. So, my lord, it is not an complete, my lord, direction, my lord, to my lord, make payment. So, my lord, my lord, I'll just, my lord, use an affidavit in this regard and may I just come back, my lord. My lord, then opposition, my lord, may be directed to be used because this is appearing for the first time.
Court relegated the issue to the authority only since a question of fact was involved.
Yes.
What was the question of fact? Whether he has made payment of the share, their share, towards the employee's provident fund or not.
Yes.
That fact finding is a fact needed to be determined first.
Lordship.
Otherwise, a court cannot pass any order. And hence, authority, the matter was delegated to the authority.
Yes.
Authority said that there is no such allegation before the appropriate authority that that amount has not been paid.
Yes.
So there cannot be any impediment to pay the amount.
Your lordship kindly sees, my lord, the
Now, additionally, the order says that the satisfy observation and adherence of other rules, not these rules.
My lord, I tell you, lordship kindly sees, my lord, page 27 for a moment. Page 27 of the first order, my lord.
So you filed a report in the form of affidavit.
Report in the form of affidavit.
Affidavit.
My lord, may I just use an affidavit in opposition in no, no, Lord, lordship kindly sees, my lord, if there is any dispute with regard to this, my lord, I cannot, my lord, reply, my lord, by way of affidavit, my lord, in the form, my lord, report in the form of affidavit. Lordship kindly makes a specific direction within 2 or 3
Court just want to shorten the area of litigation.
my lord, if he is entitled, he is entitled. My lord,
Area of
lordship kindly, my lord, direct us, my
He
lord.
came that my payment has been withheld, citing the reason that I have not paid the provident fund or their share.
My lord, that was not the claim, my lord, subject to, my lord,
account of the employee.
My lordship kindly sees what is the claim, my lord, at page 27. It is, my lord, written. What was the claim before this honorable court earlier? Lordship kindly sees, my lord.
Now you are trying to bank upon the dash order, additional order.
No,
So
lordship kindly
observe
sees petitioner is a
must
contractor.
satisfy itself. Observation, the observance and adherence to the other rule.
Yes, yes. Lordship kindly see.
So satisfy them.
Lordship kindly sees, my lord, the order was passed in a different, my lord, premises altogether. My lord, I'll just come back with affidavit, my lord. My lord, let it be, my lord, direction. No, my lord, writ petition, money claim without affidavit, my learned friend is seeking, my lord, direction.
The present petition
My lord, Mr.
That is
Dotto has.
31. Because Lordship was pleased to direct the authority to consider my case in accordance with the judgment of the apex court.
Hey, you file.
My lord, we will file in the meantime, my lord. Mr. Dotto has requested if it could be fixed any day next week. Any day next week, we will file in the meantime, my lord.
Dotto is argue the matter. Definitely is not filed.
We'll file in the meantime, my lord. We will file in the meantime. We'll file in the meantime.
This is the first prayer I am making to consider my case.
Since at the request of the learned advocate, I am fixing the matter 12:30, 1 p.m., 2 p.m. 2 p.m. actually smooth functioning of the is being hampered.
So many negligence, but my
Eh.
clerk is not there.
For consideration,
Hence, I have already recorded. You come.
We will comply within the next day.
He just want to consider his pair in the light of the Supreme Court judgment.
Yes, madam.
Whether you will accept it or not.
No.
Okay. Since on that date, on the basis of the oral submission, I pass the order. One dispute come. You come with a 2 pages report.
We will, my lord. We will definitely file it.
Court is not trying to determine anything. Court is trying to relegate the issue to you. Now ball is in your court. You consider, you reject, whatever you want, do it.
After you reject, you will again disturb.
Yes.
But only, my lord, any day next week, my lord. Mr. Dotto has requested.
I am trying to accord.
Then you can for
6 hours later. 30. 6th August at 12:30.
Next week.
Next week.
Anytime suits my. This is my prayer. At 12:31, whatever suits.
12:30
one 15 minutes. Hey, 1 p.m. করে দিন। হ্যাঁ, তাহলে কি আমি আর কোনো order is needs to be passed?
Today.
হ্যাঁ? Oh. Hard the learned advocate appealing for the respective একটার সময় মহাবতী তো 15 মিনিটে হয়ে যাবে।
I have made my prayer.
Yes. Yes, next.
Number 3.
3.
I am for the bill.
Who is your other side?
But this is a old matter of 20.
Old matter, have you given the notice?
Yes, before my. Because I do not know who is the appearing counsel before your lordship. Eastern Railway, my lord, I have made it.
You give another notice. You give another notice.
Intimating the date of my lord.
Chairman, railway recruitment cell, Eastern Railway, their presence is required. You give another notice. আচ্ছা ঠিক আছে আচ্ছা আপনি লিখুন তো আচ্ছা having heard the learned advocate appealing for the
Item number 4.
I beg to appear on behalf of the petitioner. The last occasion, Lordship was not pleased to direct me to communicate the order of the Full Service Commission. I have communicated. In the last occasion, state was taken for time for filing for the report. Well, no report has been filed.
Mr. Bari, are you appealing for state?
For the school authority.
School authority.
Well, this is the case.
Miss Nondi is appearing and Devopriya Chatterjee, Devopriya.
But despite order passed by this honorable court to file an affidavit, affidavit has not been filed. Again, Lordship was directed to as per.
So it is not motion stage, Mr. It will appear under the heading hearing.
Yes, because of
Yes.
last
Actually, since Mr. Panda, your junior or anyone on your behalf mention this matter as motion.
No, because of last occasion, but the
It cannot be.
learned state
Since
has
motion, court did not ask any motion. Yes, give the slip.
no, because of affidavit has not been filed till date. They have asked to file a report. Despite that, Lordship was
There is a direction upon the respondent to file affidavit in opposition.
Despite
This
that, they have
directs-
refused. Again, Lordship was
That means that will not change the character of the stages of the proceedings.
it was last
The
occasion. It was not appearing in the
stage of the proceedings is hearing stage,
last
not
occasion-
motion stage.
Last occasion, it was appearing in the hearings.
Having considered the issue involved in the writ petition, the court finds that the writ petition needs to be decided on exchange of evidence. Let affidavit in opposition to the writ petition be filed within 4 weeks.
Last occasion, it was appearing in the hearing, but on the prayer of the learned state, that they will file the report, and Lordship was granted that. That's why the matter is appearing on the motion, my lord.
এটা একটা returnable hearing করে একদিন দিয়ে দিন, and you give just intimation to Miss Nondi. Miss Nondi on that date stated that state most probably state expresses intention to submit a report. If they come with that report, the issue may be
And advance copy may be Lordship was directed to serve a copy of the advance copy. That has not been also served.
advance copy না
Yes, my lord. Can we see your Lordship's order, my lord?
এটা করুন তো ওই
Any day, my lord, can we? Because the petitioner is suffering since 2020.
Okay.
Is a very short, my lord, the transfer.
আচ্ছা লিখুন on 16th July 2025 when the matter was last taken up for hearing, then Mrs. Nondi, learned advocate, entering appearance অপূর্ব কর দিন 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 দিন
না এটা হচ্ছে কি
তাড়াতাড়ি দিন দেরি করলে আপনি
I am for the petitioner, my lords.
Lord, in this matter, my lord,
ওটা হ্যাঁ yes yes
I was served a copy on the understanding that since the petitioner is a employee of cooperative society and the allegation against the bank, so I was served a, my lord, I was engaged in this matter on behalf of, my lord, the Directorate of Cooperation. But I don't find, my lord, any party that register is a party to the proceeding. If register is made party, my lord, then I
Register
can.
is not the party. A cooperative bank, kindly see the cost title, my lord. And there is a direction in the year 2021 for filing affidavit.
Mr. Chatterjee, it is same it is also hearing matter
Hearing matter.
has been included
It is appearing.
somehow under the heading motion
It
same
is a
thing
mistake of my juniors also.
your junior also mentioned this matter
Matter is
Motion.
appearing under heading hearing. Kindly see hearing.
So chairman of register of
Cooperative Society.
His presence is required.
My lord, I think
This is
both
a
the
matter,
parties-
my lord, where, my lord, the suspension order was passed by the cooperative bank against the petitioner. That was suspended or suspension order is cancelled by the honorable court. Now, my lord, I want to join in my service. The cooperative bank is not allowed me to join in the service. That is the contention of the writ petition. When the suspension order,
Who is for the cooperative bank? You are,
No, my lord,
you are for the state.
I have
I'm
served,
for register.
I have served the cooperative bank respondents.
Oh. If register is added as a party,
My-
then it will be
My lord,
beneficial for you
my,
to get the instruction.
my.
So another service writ petition should be, he will,
A
am
copy
reading
of the writ petition is with me. There is no need of service. Only implement of the register, my lord, as part.
Instruction.
I am not sure whether in respect of cooperative bank register has any role regarding internal or particularly disciplinary matters.
Because every society is being, my lord, under the supervision of the register, my lord.
He want register to be added as a party. Although he will represent the register.
My lord, to that extent.
But in fact, the direction was on the bank on the previous round.
Yes.
He must have been apprised of the facts. It's a disciplinary action against an employee.
Yeah, against his employee. Order of suspension set aside.
Set
But
aside.
they are not allowing him to join.
Granted liberty to take action. This can only be done once the termination order is set aside and the employment relationship is restored. A dead person cannot be again killed. So the dead person has to be brought alive by reinstating him in service, and then proceedings can continue for the purpose of disciplining him.
Yes.
But once the order of termination is set aside, they have to either take a decision to place me under suspension or reinstate me and continue with the disciplinary proceedings. But reinstatement is a precondition for the purpose of continuing with the disciplinary proceedings once the termination order is set aside. Now, once the relationship is restored, they can either allow me to resume duties or suspend me once again. In the event of placing me under suspension for the second time, they have to place me subsistence allowance.
Yeah.
That's the law. And that's the writ petition for.
But who entered appearance on behalf of the bank? Partho Bhanjo Chaudhary and Ravi Kumar Dubey for respondent number 2 and 4. So you served a copy, fresh copy.
Yes.
And whether Mr. Mojumdar, whether register should be added.
But
I dealt with cooperative bank matter, disciplinary matters, other cooperative.
Previous round register was not a party, and not according to me, it's not required.
They have served us a copy, my lord.
So you are representing the secretary of the cooperative.
Yes, that I can.
Higher authority.
My lord. That I have no problem.
Having heard Is the matter accordingly under the heading returnable matter within bracket hearing. Huh?
Please, the court appointed a of malice or victimization or predetermination of mind. But in that context, not this matter assumes some significance.
That bank comes.
Let them. Okay. Yes.
That was 6.
6. Legends সব আমি দেখছি সব হেয়ারিং ম্যাটার গুলো কিন্তু
with the consent of the other side, I'm only paying for not today.
Not today.
Apparently, Mr. Chaudhary is in Hyderabad with his father for some medical issues.
Oh, whether tomorrow he will be available? Not this week? That would be better.
It will be on Friday.
Friday.
He's coming back today, I'm told.
Oh, so এটা Friday করে
Friday lots.
Oh. Friday application, contempt application, assign matter.
Next Monday.
Monday. Not this week, yes.
Item
Yes,
number 7.
My lord, the petitioner father was, my lord, license holder of a country spirit, a 25.
That matter advocate.
Yes, my lord. That was taken, my lord. The question that was raised upon your
Who is Tonoy Chakraborty, Mr. Tonoy Chakraborty? His presence is required.
What is the issue? What he has raised out, my lord, was
whether an advocate can.
My lord, I'll place out one Supreme Court judgment where 1956 Eviction Act, West Bengal Premises Eviction Act was being applicable. Thereafter, 97 came into, my lord. In that, Supreme Court said out, I'll place out this judgment.
That matter, you just give the reminder. That matter, the advocate, learned advocate. Learned advocate, father was a holder of a country liquor shop, license holder of country liquor.
A joint license to
Father died.
Yes, ma'am. The father
now,
died in 2017.
Now, when
I informed out to the authorities that my father died in my letterhead of advocate, my lord. Thereafter, my lord, they made.
So you are the elder brother, eldest.
Yes, ma'am.
You are the eldest.
There was
other brother is there.
Yes, ma'am.
Now the authority has taken a decision that now, in favor of only one person, one legal.
No, my lord, they have issued a new license in the joint license, my lord. I have the license of the joint also. Through RTI, I have
in favor of others.
Everybody who have been issued in 2021, my lord. My lord, kindly take the page number 3, my lord. They gave out the RTI information where it has been a license form 1.
Oh, okay. Now
at the upper it is there.
Now have you given the copy to the Mr. Chakraborty?
My lord, kindly take. No, my lord, I have. It's the first time come.
Oh.
Chakraborty is appearing, but this clerk might request not to be on behalf of him.
Not today.
My lord.
So not today. Come tomorrow. You take it with you. Keep
My lord,
it
the
with
judgment
you.
clearly says, my lord.
Okay.
Application
Preserve your energy. Preserve your energy for tomorrow. Tomorrow you have give a fight to Mr. Chakraborty. Get yourself prepared.
Should I appear for respondent number 3 and 4 in this matter?
Respondent number 3.
Well, I am appearing for the petition, but that is the evidence of service. That matter, my lord, your lordship was pleased to directed to consider the representation, the annexer.
That casual labor.
Yes, my lord. For
so you consider.
Yes, my lord. Whatever it may be.
But to give an opposition to this.
No.
Kashmir, give me 1 week's time. I want to.
So what's necessary? For that, I was not praying
he will be happy if the authority is, the writ petition is disposed of by directing the authority to consider his writ petition.
Yes, that is the only.
The court will observe that court has not entered into the merit. Huh?
That is the only prayer.
Weeks time to file my opposition.
You reject whatever given hearing, reject this prayer. Although I shall not say, I am only,
that is the only.
I am saying,
the writ petition.
I am saying that you have the liberty to accept, not to accept their contention.
No, she have to come back with instructions.
I am directing, let the authority
Yes,
take
my lord.
decision.
Dispose of the matter.
You just say, okay, Mr. Bosu, I have heard on that day. You just say whether the petitioner is still acquiring the premises or flat.
Quarter.
Quarter.
In terms
Whether
of
he
the
is in
scheme.
possession of the quarter.
Yes.
Huh?
I am in possession.
Lordship.
In terms of the scheme, it will be considered. If it is not allowed to stay,
and some
that will be rejected. My prayer will be rejected.
And you want?
Kindly see the prayer portion.
First pair allowed the quarter under settlement scheme. Pair A.
Second, consider.
Lordship, kindly see
P3 and
page
P4.
52, annexure P5.
P3 and P4, that is the representation and advocate's letter.
Page?
Page 52, Your Lordship, annexure P5.
That is the scheme.
That is the scheme.
Grateful.
Item number 9.
To place, to place. Yes.
I'm appearing on behalf of the
To play the copy of the writ petition, to place the copy of the writ petition along with all annexures thereto, within a period of 1 week from date. Within a period of 1 week.
Yeah.
Yes. Next.
Item number 9.
9, yes.
I'm appearing on behalf of the petitioner. I'm praying for a short passover as my senior is in a matter in court number 14.
On earlier date also same.
Lordship, he was just here only. The matter has been called up on court number 14.
Same thing.
My lord, may I submit one thing, my lord? This writ petition itself is not mentionable, my lord.
Lordship, I won't be able to make submissions in this matter. Lordship, I am led by my senior.
The issue has already been decided. And
Passover has
matter
been
traveled up to Supreme Court.
Huh?
Matter traveled up to Supreme Court.
Okay, Passover, let his senior come. Call him immediately.
Item number 10.
থাকে তো এক পক্ষ থাকে। সকালবেলা আপনার মাথা খারাপ করে দেবে, আপনার ম্যাটার খালি ঢোকান, আর যখন ম্যাটার নেবেন তখন দেখুন না এই পক্ষ আছে না ওই পক্ষ নেই। হ্যাঁ।
That you also will refer the matter to the mediation. I have taken the instruction. So you also can pass an order referring the matter to the mediation.
Oh, yes. There's a rule 22 of West Bengal apartment owners rule. West Bengal apartment ownership appointment ownership act and the rule 22. Rule is that what would be the maintenance charge, service charge, such and such, that would be taken into in aggregate, then divided by the equal
share among the flat owners.
Among the flat.
So can I refer the matter to the mediation? I have taken the instruction from my client.
Settle the issue.
Not settled. They will not settle.
None is appearing on behalf of the committee.
I have served notice. On the last occasion, also was pleased to direct me to serve the notice. I have served. Initially, there is a dispute with regard to the deed is concerned. That matter went up to arbitration. I succeeded in the arbitration. Award has been made in my favor. Thereafter, they rectified the deed. Now this is going on. So I have taken the instruction. Second, refer the matter to the mediation officer. Twice I have served.
Upon the state, have you served?
I have the affidavit of two affidavit services there. Last occasion they have appeared. Mr. Omritolal Chatterjee had appeared.
No, last they appeared since
the matter was called on by your lordship on last occasion.
The last occasion, I was informed that Mr. Nilotpal Chatterjee has been entrusted with the task of.
So thereafter, matter was adjourned and your lordship taken up 1 second and only make it not today. There is no order has been passed on that day. Mr. Omritolal Chatterjee, led by Mr. Nilotpal Chatterjee, had appeared. I have served notice and I have given the two affidavit services there. There are two affidavit of service.
Today you served in terms of the order dated 7th July.
That is affidavit of services there, my lord. I have served. There is two affidavit of service.
আচ্ছা আপনি লিখুন তো despite service the respondents are represented. agree. But another party is the
My lord was recorded then not to FM.
আচ্ছা ইয়ে আচ্ছা আচ্ছা আমি আমি ইয়ে মিস্টার সাচান সাচ ইয়োর নেম প্লিজ
I led by Mr. Nilot Paul Chatterjee, my lord. I am appearing with Mr. Chatterjee.
আচ্ছা ওনার নামটা দিয়ে দিন হি ইজ ইন কোর্ট টুডে
Yes, yes.
আচ্ছা আপনার ওই দে মিস্টার চ্যাটার্জি ইজ
Eleven.
11
My lord, I am for the state respondents.
Huh?
Am I audible? Am I audible, my lord?
yes
Yes, my lord. I'm in circuit.
yes
I just tell the case, my lord. My lord, petitioner before your lordship is the son. The parents, father and mother jointly executed a deed of gift in favor of the petition unconditionally. Now, the mother alone filed an application under section 5, read with section 23 of the Maintenance and Welfare Parents and Senior Citizen Act 2007. Now, the Honorable Tribunal passed an order. This order is at page 92, my lord. Opposite part order that for declaration of the regarding transfer of the mother, insofar as the transfer of the mother's share as void under section 23 of that act. I say that this order is not proper, it is not sustainable. My first ground is that, my lord, you will also kindly see section 23 for a moment. My junior is books. Kindly give the books. And section 23 for a moment. 1. When any senior citizen...
coming. I'm reading now. She is leading a ignominious life in the daughter's composite gift in her other signatory with her disease suspect to work with it.
Section 23.
Section 23.
I read mine.
Yes.
And my first submission, section 20 says, that if there's a condition that son or daughter fails to provide the needs of the mother or parent, they can, it can be declared as void. In the present deed of gift of deed,
There
there's
was no such
con-
condition. There was no
Yes.
such condition.
condition, but it was I am
Yes.
covered by the judge.
Common thing. That
I
in the
common-
deed, there was no such condition that the taxpayer shall provide basic amenities such and such.
Yes.
So
I'm
the,
covered by division.
so
I'm
the
covered
ma-
with, I'm covered with judgment of both the judgment of our High Court and the Supreme Court both. And my
Yes.
junior will this is 2022 SSC Online Supreme Court cases 1684, para 15 and 16.
Yes.
Para 15 and 16.
Yes.
So far, judgment, simply Supreme Court says it's a sine qua non. Unless it is given in the deed, you can't invoke section 23. That's it, 15 and 16. Next matter, our High Court also division will say this is 2018 1 CHN Calcutta 481. This is Devashish Mukherjee. Now discuss, I'll make a another submission.
Okay, this judgment para division bench.
This judgment was para 11 and 14. 14 is the relevant part. I have another fold of argument, my lord. Because can be considered for argument's sake, assuming that such conditions not given in the section 23, such conditions that is not giving the deed. But you're also going to appreciating the social impact about beneficial legislation, preamble of this act, and can see preamble of this act. For a moment, they may argue this, that it is a beneficial legislation. Can you see the preamble of the act, my lord, for a moment?
Okay, I've got your point. Yes, Mr. Chatterjee.
Kindly seize the relevant portion of the deed. So that page 34.
Yes.
So the last few lines, Willard, the bottom of the page. অনুরূপ তুমিও আমাদিগকে যৎপরণাস্তি ভক্তি শ্রদ্ধা ও সেবা
Yes, it is a considered as a natural love and affection. It's the consideration.
and also because of the সেবা যত্ন দ্বারা পিতামাতার প্রতি পুত্রের দায়িত্ব অতীব নিষ্ঠা ও কর্তব্যের সহিত পালন ও বহন করি আসিতেছ I say this is present continuous
আচ্ছা বিবেচনায় আমি
করিয়া আসিতেছ is present continuous. You have been doing this. That doesn't mean, Mr. Ambulish Rai, hello, that the moment I execute the deed, you'll be, Malad, in a position to say that that's the past. Korea ashitecho. You
This is
are
present perfect tense.
doing this. And what happens is that the moment this deed is executed, but
problem
of the riders of the precondition,
problem
I say this
when the deed is scribed by Muhur.
Yes.
এবং ভবিষ্যতেও করিয়া আসিবে এই আমার দৃঢ় বিশ্বাস.
This is present continuous. Korea
করিয়া আসিতেছ এবং ভবিষ্যতেও করিয়া আসিবে ইহা আমার দৃঢ় বিশ্বাস।
that is implied.
That line could have saved you.
That is implied because, my lord, it doesn't say that I have had enough for you. You have made enough for me to let me survive for the.
Any such words?
I
No,
say
there there's no such.
the last line is sufficient. Korea ashitecho means Korea ashitecho means you are doing it. You are doing it. You not that you'll.
No, this is a consideration of the gift. My learned friend, this is a consideration of the gift.
And I narrate the history of this case.
Okay, so whether this word,
this is one limb of my.
The words whether can serve the.
This is one limb of my argument, my lord. The other limb is that, my lord. Kindly see section 23(2).
Yes.
Where any senior citizen has a right to receive maintenance out of an estate, and such estate or part thereof is transferred. The right to receive maintenance may be enforced against the transferee if the transferee has notice of the right or if the transfer is gratuitous. This is a deed gift.
This is general term.
This is deed gift. This is a gift deed. But so this is a gratuitous transfer, but not against the transferee for consideration. I am not that. So even in this case, my lord, even if the transfer is made, because it is not without any consideration, it is gratuitous, the duty to maintain survives. That is the interpretation of a three-judge bench of the Supreme Court, my lord. Kindly sees. What he does, what the petitioner does, the moment this deed
Chatterjee, it would be, suppose one person has a estate. He has made at a start, and he in that document he stated that a certain portion of the amount will go every month to a particular person from the start or from the earning of the start. Then if that property is transferred, the transferee shall be bound to pay the certain portion to that person, because the condition is attached and condition created by the author of the task.
Here the
subsequent transferee cannot modify.
Here what he does to the estate is nothing to do with me. It could have been rented out. So if the estate could have fetched income, it was his duty, notwithstanding the transfer, because the transfer is gratuitous, to maintain me thereafter. This is the interpretation of the Supreme Court, my lord. I'll supply that. But here he does exactly the opposite. But the moment it is executed, my lord, I am thrown out of my house. I take shelter in my daughter's residence. Now I am elsewhere outside Bengal because she is outside. But that is not the spirit of section 23(2). This is transfer with notice. The son most certainly had, well, the knowledge that he was bound to maintain me, and it was a gratuitous transfer.
This is not a question of maintenance. That has not been given.
Let me complete. I didn't interrupt you, Mr. Roy.
Yeah.
But this is not satisfied in this case. Well, very briefly, I give the narration of facts, well, what happens after the deed is executed. I say my first limb remains that this is present continuous, the expectation that he would maintain me as he was doing all along. Not that his duty to maintain ends, well, terminates with the execution of this deed. Korea ashitecho. That doesn't mean that he has no further right. Yeah, he is denuded of the duty to maintain me because this deed is executed. How he is surviving? He is surviving by maintaining, running a 3-storied electronic shop in the town of Habra on the highway. That was the business of my.
Chatterjee, it is a moral duty.
It is a moral duty, but
was initially before
kindly sees the
promulgation of this act, Maintenance and Welfare of the Parents and Senior Citizen Act, it was a moral duty.
Kindly sees the interpretation of 23(2) by Supreme Court.
Yes. that any deed of gift is executed. You just take me to the pattern point that Supreme Court observed that any deed
What
of
gift, what 23(2) can be interpreted to mean?
It is protection of woman under Domestic Violation Act, the matter. Yes.
Kindly sees paragraph 19 and 23.
19 and
23.
23.
Kindly first sees the last 5 lines of paragraph 23 at page 749.
Yes.
Arguably, the language of subsection 2 is broad enough to also cover a situation where the transfer is by a senior
Paragraph 23 you are reading?
Yes, 23, the last 5 lines. Last 5. My Lord wanted pattern the point.
Arguably, yes.
Is broad enough to also cover a situation where the transfer is by the senior citizen, in which event the transferee with notice of the right or a gratuitous transferee, my son is a gratuitous transferee, can be made subject to the enforcement of the right against the transferred estate.
You read the first line of that paragraph.
Yes.
On the other hand, subsection 2 of section 23 envisage a situation where a senior citizen has a right to receive maintenance out of an estate.
Yes.
Yes. Yes.
That means this subsection will be applied where a senior citizen has a right to receive a maintenance out of an estate.
That right is coming from section 4. The right to receive maintenance. The right to receive maintenance from the child, from the son or daughter, comes from section 4.
Mr. Chatterjee, right to maintain, right to seek maintenance or to obtain maintenance has been recognized under 125 CRPC also. Okay, has been recognized for the first time. The right of a parent, of a father or mother,
yes,
to get maintenance from his children or child has been recognized first time by our legislature in Code of Civil Procedure. Subsequently, 207 also recognized such right. That is another aspect of the matter. But when it is legislature took cognizance of the fact that taking the land or getting the land transferred in his name from the parents, now the parents are being driven away from the house. To address this situation, this act came. Now, in the provision of section 23 has said that if it is found that after commencement of this act, that is after 2007.
I'm not on 23(1) so much. I'm on 23(2). 23 subsection 2.
Okay, that if any property is transferred by a senior citizen, transferred by a gift or otherwise, that means transfer.
Yes.
Sale, such and such it may include. Subject to the condition that transferee shall provide basic amenities. So transfer must be subject to the condition that you will provide the basic amenities to me. You are actually, what is the consideration of the deed of gift? Natural love and affection.
Yes, and also the fact that she was maintained, looked after.
Since I love, I have affection to
the fact that she is being looked after properly by the son. And also, my lord, also the last 2 lines of page 34, because she was looked after by the child. Korea Ashitecho does not mean the moment the signature takes place, execution takes place, the duty ends. This This, my lord, being a law what it is, this, with respect, my lord, has to be stretched to include a deed of this type. Otherwise, my lord,
Mr. Chatterjee, I have not made up my mind. It is a conditional gift. It is like a conditional gift. By executing the deed of gift, I am conveying the property to you, but subject to the condition. Unless the subject is fulfilled, the deed of gift will go.
This line, my lord, in Bengali,
It is a conditional gift, and you are maintaining me, and hence I am going. That means it is a present consideration. What is the motive behind execution of gift?
Present
Since you are maintaining,
that nothing will change after the execution.
Future condition.
Kindly sees it is present continuous. The expectation was nothing will change after the execution. To be Korea ashitecho. So I do this. The implication, my lord, with respect, the interpretation has to be that the lady, my lord, and her husband, my lord, the expectation was the situation will not change merely by the transfer.
Expectation and condition is totally different. I excuse my reputation.
My lord, sitting there, my lord, will make every effort to stretch the language of these last 4 lines to cover a situation, my lord, envisaged under section 23(1) and also 23(2). 23(2), my lord.
Suspension is good enough to cover where transfer is by in the event transfer is.
That is 23(2).
In the event in which event with notice of the right, a gratuitous transfer can be made subject to the informants of the right against the transferred estate.
Yes.
But here,
against the estate,
first line is the envisage a situation where the senior citizen has a right to receive maintenance
of
out
course.
of estate.
Of course, I could have rented it out.
Can we allow me one line, my lord?
I also wish to place the order of the SDO, but I had. I had, my lord, waived my right to receive maintenance because of the order that was passed. I now wish to pursue that if my lord is of the opinion that
maintenance has not been given.
So I am inviting affidavit.
If she survives this
Hello,
period.
can we allow me one line, my lord? Please.
You right?
Even when her husband died, she was not allowed to visit the house to have a last look at her husband. When the husband died, but he was bedridden. That is why they couldn't throw him out. But because
can you see one line of the petition for a moment? Can you come to this?
And when her husband died, the father, she is not even allowed to enter the house to have a last look.
What he has said about the husband, can you see? My lord,
I
the
can't
petition
hear.
can come page
He is not
67.
audible.
You have said many things. Can you see?
Okay.
One minute.
If a gift of this type,
for a moment.
If a gift of this type can invite such behavior, but my lord has to
I'm
take
not
a judgment
anything. You have said
appropriate.
everything. My lord, for a moment. Can you come to page 60, application 66? For a moment. I have
He
one
is
line.
running an electronics goods showroom on the main highway in Habra town.
This you have said a lot of times.
The law cannot envisage, does not, that I have to
Mr. Chatterjee, kindly, I'm not disturbed. I'm trying to point out one. And can you see?
I had always learned, Malad, when the judge is with you, you need not say much.
But can you 66 for a moment? I know it.
Judge is with you, no.
I'm addressing
one
this to
Supreme Court.
That I learned from you many
unfortunate. I shall observe in my order that it is unfortunate litigation when a father, a mother and his own son. Own son is fighting in this petition.
Kindly allow me one line, my lord. Kindly see 66 for a moment. Kindly see application page 66 for a moment.
Okay, I am inviting a short affidavit from them.
But 67, for a moment, kindly fix. One line, kindly in the petition, kindly.
The transfer does not end
Oh,
the
kindly
duty
allow
of the
me,
bank
please.
to
Mr.
maintain the
Chatterjee,
bank.
Mr.
The
Kindly
transfer
come to
does not
67.
and does not. That is the
Your that remedy available. You can file 125 proceedings. You can.
I wish to, if my lord is inclined to be against me, I wish to go back to the SDO because they had not pressed my prayer for maintenance, although that was there in the application. Because of the order that was passed, I thought I will not pray to, I will have to pray to my son for my.
You cannot get
That
both.
is the spirit which
My
went
lord,
behind.
kindly,
I did
one
not.
line,
You can file 125 proceedings.
That is why I say that was not pressed. That is why, because the vacating order was passed. But that does not mean that I have forfeited that right forever.
You have not challenged the order. You have not challenged that order.
Why should I challenge the order? The order was in my favor, vacating.
Vacating, but omission to pass any order.
Because they've said I do not want it. I'll live from the income from this house. Now the situation is changed. My lord will also give me the right to approach.
Whether any tenant has been inducted in the property.
That commercial property is separate. There he is making lakhs by selling electronics goods.
Now, whether the subject property any tenant has been inducted.
This is always
the petitioner would get the rent.
Always a deemed income. If necessary, let it out to pay my maintenance. The law doesn't foreclose that option. Where he gets the money from, that is none of our lookout. Why should I be forced to?
Okay, I am fixing another date.
Why should I be forced to take shelter in my daughter's house?
Yes.
Kindly one line, my lord, can you allow me one line?
One week.
Page 67.
The present has been paper challenging the legality and propriety of the order passed by the subdivisional
Maintenance tribunal. Maintenance tribunal.
Passed by the.
My lord, kindly allow me one line, my lord. So you lordship.
Yes,
and
yes.
Kindly come to 67.
As a part by the presiding officer, Tribunal for Maintenance and Welfare Parents and Senior Citizen Act, 2007, and subdivisional officer Barasat within bracket Sodor, North 24 Porgonas. Acha, North 24 Porgonas. Acha. After declaring the transfer of property to the extent of the share of the petitioner therein, namely Srimati Nibha Bosu, in favor of the OP, in favor of the
son,
her son, in favor of her son, as void. Stopped. The order, additionally, the order directed the OP and his family members to vacate the petitioner's shares of the property to the extent it was occupied by them within the time specified therein. Stop. Mr. Royal and a senior advocate representing the petitioners submits that it invites my attention to the provision of subsection 1 of section 23 of the Maintenance and Welfare of the Parents and Senior Citizen Act 2007, submits that the existence of a condition that the transferees shall provide basic amenities and basic physical needs to the transferor is a sine qua non to the application of the subsection of 23 of the 2007 Act. He submits that the recital of the deed does not contain such condition. Therefore, in the given case, the presiding officer misdirected itself in applying the subsection 1 of section 23 and in directing the petitioner hearing to vacate the
The split portion.
private respondent's share in respect of the property in question. Stop. In support of his contention, he placed his reliance unreported, placed his reliance reliance on two decisions reported in 2022 SCC online SC 1684 within bracket Sudesh Chikara versus Ramti Devi and others and 2018 volume 1 CHN page within bracket Cal CHN Cal within page হচ্ছে A481 bracket হচ্ছে Devashish Mukherjee and Sanjeev Mukherjee versus Sanjeev Mukherjee and others. ঠিক আছে আচ্ছা Mr. Chatterjee learned advocate representing the private respondent vociferously opposed the petition. Vehemently oppose the petition. He invites my attention to the certain portion of the recital of the deed and submits that in the deed it was specifically recorded that the transferee has been maintaining transferor at the time of execution of the deed. Stop. He submits that this sentence give a rise to a legitimate expectation that the transferee shall go on maintaining the transferor. Stop. He submits that taking note of this, it can easily be construed that in the present case, the subsection 1 of section 23 would be applicable. Stop. In support of his, furthermore, he submits that here subsection 2 of section 23 would be applicable. Would be applicable applicable and had the property or the of the transferee share was let out, the same could have faced a certain amount of income. Thereafter, the estate and the property could have brought certain income for the transferor. Considering this aspect, in the present case, according to Mr. Chatterjee, subsection 2 of section 23 will be applicable. He submits that the petitioner complainant make a prayer for maintenance.
He had made the application. He had made the prayer in the application, but because this order was being passed, she had decided not to press that. That is recorded. Now, if my lord is against me, my lord surely has not made up my lord. My lord will not shut the doors.
My lord George is not against anyone and for anyone.
My lord will not shut the door to
George is not bothered who will win, who will lose.
No, my lord,
But what is the decision of the Supreme Court and the proposition laid down to the Supreme Court
23
is binding upon this. So
naturally.
now I have stated that he has been going on or maintaining myself. That would not create the condition that he will go on doing so.
Korea ashite chile would be past tense. Korea ashite cho is present continuous. Present continuous.
That should be future term.
There is a future tense. There is a future tense.
Future,
that he shall do it or he shall be doing it.
That I leave it to my lord, but my understanding was that
he must read the tense first. My lord, your lordship can explain.
Acha, your name, please. Acha, Mr. Kapas Lanet advocate representing the petitioner submits that the incident was investigated into by the jurisdictional police. And upon inquiry, it revealed that the petitioners, that the private respondent has been deprived by the petitioner hearing. And hence the police authority has issued a notice.
Under what provision, my lord?
Asking the petitioner hearing to vacate the share of the private respondents.
In percentage order, my lord.
So that order you have to challenge.
No, that's not order. Police has not passed any earlier. Police has, in compliance of this order of the tribunal, give the notice. And the order which is under challenge before lordship, pursuant to that,
Had the learned advocate appearing for the respective party peruse the materials on report. It is unfortunate that one mother and son is locked in this litigation, in such sort of litigation, and at the December of her life, the mother was forced to approach the SDO with a plea that his son is not taking proper steps for our maintenance.
Sorry for interrupting. Kindly see.
It is my observation. Although
before the kindly come to
under an expectation that his son will look after him and take steps, all sort of steps for our maintenance during her last days in her life, he executed a deed in favor of his son.
Both parents have done. She has said the husband also. This is I'm trying to place people also kindly 67 for a moment. For then you also change the mind. Can you come to 67 for a moment? That is what she said. She said, my husband also cheated me. Can you see this?
However, decision of a court of law would be based on the settled legal position and on the statutory provisions. Stop. Section 23, within subsection 1 of 23. Stop. To shed a light on the issue involving the petition, it would be prudent to quote the provision of subsection 1 and 2 of section 23 of the 2007 Act, which are as follows. বলে এটা বইটা নিয়ে ঠিক আছে stop. Therefore, a bare perusal of the provision of subsection 1 of section 23 suggests that the applicability of subsection 23 is subject to the certain condition. And that condition is that the transferee shall provide the basic amenities and basic physical needs to the transferor, and such transferee refuses or fails to provide such amenities and physical need, and then such transfer of property shall be deemed to have been made by fraud or coercion or under influence. Therefore, the applicability of subsection 1 of 23 I mean, subsection 1 of section 23 can be applied on fulfillment of certain condition. Stop. আপনি লিখুন এক, the transfer either by way of gift or otherwise shall be subject to the condition that এটা এক Roman 1 that the transferee shall provide the basic amenities and basic physical needs to the transferor. Colon. 2. Such transferee refuses and fails to provide such amenities and physical needs. Therefore, unless these two conditions are fulfilled, the subsection 1 of section 3 cannot be applied. Similarly, subsection 2 envisages a situation where a senior citizen has a right to receive maintenance out of an estate. Support of the views shall be obtained from the judgment of S. Vanita, bracket Sutra. Vanita. Therefore, unless the condition that a senior citizen has a right to receive maintenance out of an estate, the subsection 2 of section 23 cannot be applied. Stop. Undoubtedly, in the deed, it was recorded that the transferee had been going on taking steps to maintain the transferor at the time of execution of the deed, but on the date of execution of the deed. But this sentence is not broad enough or sufficient enough to include any future events. Since one person is doing certain work currently, such action is not an assurance that such person shall go on such work in future. In the decision of Sudesh Chikara, the Honorable Supreme Court ruled that effective transfer subject to the condition of providing basic amenities and basic physical needs to the transferor is sine qua non for applicability of subsection 1 of section 23. That means this condition speaks of the future events. It is not indicating any events or any occurrence at the time of or on the date of execution of the deed and deed of any conveyance. Therefore, I am of the considered view that the sentence as identified by Mr. Chattopadhyay to be a substantial compliance of the requirement of subsection 1 of section 23. I am not agreement bollam. Therefore,
one page bullet of the writ petition, page 85, where he says that I will continue to maintain. Kindly see page 85 of the writ petition. That is his affidavit before the Criminal Code.
It's 18.
Criminal
Page
proceeding.
85, page 85.
Criminal proceeding. That is this criminal liability.
He says that I'll continue.
Yeah,
this
I can say.
amount he earns, he'll continue to be, he's keenly ready to take all.
I just stop. আমি ওখানে Mr. Chattopadhyay,
But that is
Mr. Chattopadhyay, my attention to one sentence. Made by the petitioner. In his written statement filed in a proceedings initiated against him.
Domestic violence.
Under the PWDV Act, Protection of Women from Domestic Violation Act. লিখতে পারবেন তো?
But then can you take one line also, mine also? Can you come to page 67 bottom movement?
Wherein the present petitioner undertook a liability to go on
All
maintaining,
responsibility. To take all responsibility of my mother.
undertook the responsibility to take all steps to maintain his mother, to look after and maintain his mother. Stop.
You can you see for what he said?
However, as as mentioned earlier, that such sort of undertaking is required to be incorporated in the recital of the deed.
Sorry, the Supreme Court has said that a separate undertaking given somewhere, not part of the deed, is also applicable. Page 2025 Supreme Court. That need not be recorded in the deed.
Why?
2025. Just
But it should be hard.
One by one, you are going on. Why? Subsequent instrument. Whether it would be part of the instrument.
There a separate statement was there. The Supreme Court took that into consideration.
The morality one thing, legality another thing. You saw whether it would be part of the deed.
There is an undertaking, no doubt.
Yes, at that time, deed of rectification is done. Deed of modification can be done.
This is a separate statement that the Supreme Court took cognizance of.
That is another Supreme Court has 142. So I do not find any justification for applying the provision of subsection 1 of section 23 by the presiding officer and to direct the present petitioner to vacate the private respondent.
25 USCC 797. The paragraph at the top of the page.
Paragraph
at the top of the page, Manoj.
One promissory note dated after because
that was not part of the deed. This is an affidavit.
That is
an affidavit.
Acha. I have carefully gone through the decision cited by Mr. Chatterjee. However, those are.
My lord will take this as cited. My lord will record.
Acha. Those are distinguishable on fact. ঠিক আছে? আচ্ছা in the so in view of the discussion and reason set out in the proceedings paragraph, the order and the challenge in this petitioners set aside. Okay.
But
however, this order shall not preclude the private respondent to approach the presiding officer
by way of a fresh application.
In future, if situation so demands.
By way of a fresh application under section 4.
But why?
Section 4.
You have right everything.
If law permits her to do so.
Applies. Notwithstanding the fact that
he should put everything, Mr. Chatterjee.
এটা বন্ধ করেছেন তো?
I've been stopped. উঠিয়ে দিল নাকি?
Okay. Your 2 PM matter?
Yes.
Yes.
This matter item number 133 to 135.
Excuse my importance to remind your lordships, my lord, on the last occasion, when the matter was heard, my lord just asked by other side, who is happy with the material, you take instruction. Because in short, let me explain. My lord, my clients, they have been doing their business, they had been doing, because forcefully they have been evicted, very illegal, I'll come later on. So they have been doing business in the Taliganjali, the metro rail complex. Now, my lord, initially there is no problem, nothing. So naturally, ultimately, under certain circumstances, my clients were compelled to approach the Honorable High Court. One order was passed by Justice Dipankar Datta, and that order is very interesting. For these reasons, protected me. It is a part of the record, but that is not a hazy fresh painting. Our copy which is very interesting. Have you got it, my lord?
Yes.
Since common question of law and facts are involved, the 8 petitioners have joined in the present petitions. They are agreed by the order dated such and such passed by the estate officer in exercise of the power conferred by him by public premises eviction author occupation act 1971, holding them to be unauthorized occupants of public premises. It is not in dispute that the license issued in favor of the petitioner expired on 31st March 2005 and has not been renewed since then. However, the policy of the Metro Railway is in not granting license on a long-term basis was subject to challenge by the petitioner by filing a writ petition. The writ petition was admitted for hearing in the month of January 2006 and directions for exchange of affidavit was passed. However, no interim order was made on the petitions. The said writ petition came up for final hearing before the learned single judge on such and such date. When the respondent filed their affidavit in opposition in court, and due to such belated filing of that is the Metro Railway. The belated was the same. The final hearing could commence, and the same was adjourned. Immediately thereafter, the impugn order appeared to have been passed on such as holding petitioner to be unauthorized documents. Having heard the learned counsel for the parties on the questions of extension of interim order, it appears to this court that final hearing of the writ petition in which the policy of the respondents has been challenged was thought by the Metro Railways authorities due to laches in not filing their counter affidavit on time, which prevented the petitioner from having a decision from the court on their claim. The writ petition has once again been listed for final hearing and is awaiting decision by the single judge of this court. Much would depend on the outcome of the said petition in relation to the issue as to whether the petitioner unauthorized occupants or not. If the writ petition filed by the petitioner 2005 succeeds and the consequential order are passed in their favor, the same would have direct effect on the proceeding intimated by the estate officer under the said act. In the event the petitioners are evicted in terms of the impugn order, they would really not suited them. The railway, in the considered privacy view of the court, can be allowed to take advantage of their own default, keeping in mind the factor of balance of convenience inconvenience and the extent of prejudice to be suffered by either of the parties if the interim order is extended. This court is of the further considered view that end of justice would be subserved if the interim order passed on sunset is extended for a further period of 3 months from the date of until further order, whichever is earlier. It is ordered accordingly. The petitioners are directed to force the present occupation charges 10,000 per square feet. There lies the problem, my lord. Problem starts from that. Very interesting. Square feet per year from as agreed upon the parties only without prejudice to the respective rights. The material authorities shall assess the areas and shall inform the petitioner individually and such. This will give the latter part is not much important. So then at the time when the order was passed, my Lord Justice Datta passed direction 10,000 per square feet. This is the square meter. And railway
directed to hear out the the main writ petition.
No, the application, my application. That is the last. That's why you are directed to take instruction.
That direction was there to hear out the entire.
No.
The
Let me
application was filed. Your lordship was also heard out the 3-4 application out of that, my lord, 3 application was disposed of probably when your lordship were sitting at courtroom number 10. And my lord, in that application, your lordship was refused to pass any interim order.
Let me finish, my lord. Question is this, my lord, if really that is so, there is no need for the honorable court to direct them. Well, Mr. Banerjee, you are ready to pay the money. And yes, I have been paying that. They cannot deny that, but not 10,000 per square foot per square meter. Most interesting thing is this, kindly notice, my lord, for more than a decade, and it was also communicated by the railway officers to the authority that 10,000 square amount per square meter, and we have been paying, nothing wrong. In 2021 or something like that, suddenly there is a change in the administration. One gentleman officer came and said, no. Court said 10,000 per square foot. My lord certainly can ask me, Mr. Banerjee, why did you not file this application earlier? For these reasons, I could have understood. Just after passing of the order, they refused to accept 10,000 square meter. I could have understood. From their own letter, I place the petition. From their own letter, it will appear that, well, they say 10,000 per square meter. They also know, everybody knows. But by mistake, that was done. And when they say, no, since you have committed a default, so I will evict you. And forcefully they locked and evict me. So that is why I file an application. Kindly take time to see my application. Very interesting. And they are affidavit.
Mr. Banerjee, filing an application, actually we will be sitting, you consider whether it would be sitting in appeal over this order or not.
No, it is a correction.
You have not immediately filed any modification application.
No,
Not family.
No.
But actually it is an interim order.
Yes.
If the writ petition is finally decided, then this order merged with the final order.
Kindly appreciate one aspect, my lord.
Then your whether as per agreement it would be square feet per square feet or per square meter, that issue will be addressed.
No, kindly appreciate one aspect. Once it is found that it is per square meter, then since I paid it, no question of eviction, no question of default, no question of notice. So that's why, and for more than 10 years, they accepted the rent and the correspondence, it will appear, railway authority, it was informed by the officer to the railway authority and the lawyer, that 10,000 per square meter. Kindly come to my application, my lord, just once. 14 years, can see. Can you come to can see? And their affidavit.
In this petition, this court has been called upon to decide whether the orders dated 4th May 2007 passed by the state officer is justified or not.
One thing is very clear.
Yes.
Kindly see. They say that, well, I will not execute any long-term lease. I say, please do that. We agree to pay. So that was the issue for which my client was compelled to knock the door of the Temple of Justice. Then Justice Dotto, there are two matters. Says that is a vital aspect. That's the first point. If it is found that, well, the railway authority certainly can execute the long-term lease, there is no problem since parties have agreed. So that should be heard fast. So in passing, at the time of hearing, say very well, interim order I will extend, provided you pay the money. As yes, I have agreed to pay that money. Then this order is very good, far-reaching effect. But once I paid, then I cannot be evicted. They accepted it for more than 14 years.
No, because of the fact, at that time you didn't appear.
No.
On 24th May 2025. Why I am saying so? That remaining application were filed. This court passed an order. So in view of that, those applications can be heard along with the main writ petition. Parties are invited to advance their argument on merit.
Yes. I am arguing merit, my.
They are merit on the writ petition.
I reply.
Argue on merit of the writ petition. And not in respect of any application. All application along with the main writ petition. You kindly
very rightly, my lord, put me this question. Let me ask.
Because this court, I can recall this court passed this order. This issue was raised that many application has been filed and has been filed. And whatever the application here, ultimately, the challenge under this petition is the order dated 4th May 2027, whereby you are declared as unauthorized occupant. So whether this order is justified or not, only the issue to be decided in this petition.
Well, one thing is very clear. Let me explain, my lord.
Yes.
Because they say you did not pay according to the court's order. There are two matters. Again, I said the court's repetition. One is, my lord, that I wanted let there be long-term lease. They didn't agree. So again, such refusal or inactions, I challenge. Now, second petition, when it came up for hearing, Honorable Justice Dotto says that, well, that is a very vital aspect. If it is ultimately found long-term lease can be executed, everything will over. So both the matter to be heard and that matter to be heard first. Now, at that juncture, court says, intimate has been expired. I'll extend, provided you pay this amount. Now, it's a very right on mind. So once the money is paid, but for the last 14 years, why I'm evicted? Can be very significant. I could have understood before service notice or anything has happened, prior to that I was evicted, I could have understood. Man was very rightly put to this question. It's the main matter. Why? My application is much more, has got significance. When I paid the money, they accepted. The correspondence. Both of us are under impressions, rightly, that, well, it was at the rate of 10,000 per square meter. And that was also communicated by the lawyer to the railway authority. The railway authority accepted that. And I've been paying for the 14 years. Nobody disputed. Suddenly, they woke up from the slumber. They say, no. Order says 10,000 per square feet. Kindly appreciate how much it comes to, how much? 150 square feet. 10,000 per square feet means it comes to 1 crore something. 1.5 crores. So month is 12 lakhs and or 12.5 lakhs. So one tea stall, 150 square feet, it is people's house to believe. It can't be. So there is mere mistake, my lord. It can't be. 12.5 lakhs for 150 square feet, even in the, my lord, Bombay, it is not possible per month. So it is impossible, a mistake. So realize that there is a mistake. Since party, railway authority accepted that, and railway authority started taking money at that rate, 10,000 per square meter, there was no problem. Suddenly they came and they say, the intimate is vacated because they have not complied with the court's order. Get out, put the lock, and everything is thrown out.
Ultimately, they have evicted you.
Forcefully taken possession.
As on date.
As on date, because I did not comply with the court's order. Can you mark it, my lord? Okay. Then I find that is very significant. So once it is said, my lord says no, it must be, that can always be done. Had it been a case, even though Mr. Justice Dotto is present here, it depends on the determinations. It is not a contempt, my lord, even determination. So today, suppose my lord passed an order. Tomorrow, my lord said for the determinations, particular determinations. The honorable judge who is taking that particular determinations, before him, he'll have to file applications. So application for correction and modification is not a question of appeal. My lord, that can always court can do that. That is a very vital aspect. That court always court can do that. But it carries serious consequences. I could have understood that well. Whatever order was passed, very rational order, 10,000 per square meter. I did not pay.
Okay, before that, Mr. Banerjee,
my lord,
kindly said how many applications are pending and for what purpose it was filed.
My lord, so far my application is concerned, my lord, that is can number 3.
Can 3?
Yes, that's only application.
Can 3 of, however, can 3 of 2021.
21.
It was filed for modification of this order.
Yes, correction and modifications.
Modification of this order.
And correction.
Modification and or correction of this order. Of this order. If, now can 5, 6, 7, 8 and 1 also. There can 1 still alive, can 1 of 2022.
But I cannot see all this.
Can 5 of 2023, Can 6 of 2023, 7 of 2024, 8 of 2024. Most 5 more applications are pending.
But I'm not engaged. I don't know.
Hence,
I don't know. I'm concerned with the 3. 3, if
your 3, your modification application should be considered.
Yes, but if my
if it is found that you are required to pay your rent as per square meter, that would be taken care of. Don't worry.
Matter ends there.
That would be taken care of.
Matter ends there.
But unless the main petition is disposed of, so all this remaining application will come and clog the carriage of proceedings.
No, kindly appreciate
one by one you are going on filing application.
No,
actually court is not being able
I can assure you, I can assure you, my lord, those who have not come, I cannot take the responsibility. And my client has got no other application, no other grievance. Because if it is ultimately found by Lord says, no, I found it is an unreasonable, it is a mistake because it can't be. 12.5 lakhs per month, it is the people's trust. It can't be. So, my lord, once this application is rejected, then main matter will come. If it is allowed,
and I told your junior to come with and to do one homework and to come with and just 1 page information. Can 1 of 2002 file for this purpose? Can 3 for this purpose? Your junior has not done it. Now it is the court.
Submission one thing, my lord.
It is where is court find out. It is the court is to find out. In the meantime, what contempt application is pending?
My lord, that order is already my lord reached in its finality, my lord.
Which order?
With great respect to my lord, esteemed friend, my lord, kindly see. My lord, kindly see why I am saying that order of the Honorable Justice Dipankar Datta has reached its finality. My lord, kindly see my opposition at page.
No, then I'll place my lord. If there is opposition, I'll place application.
Page 33.
Never denied that money has accepted for the 14 years.
Page 33, my lord. That order already passed by this honorable court, the then Honorable Justice Vivek Chaudhary, dismissing the subsequent, my lord, writ petition dealing with these points. My lord, kindly see page 33. Can 3 opposition or any opposition of my of the application, my lord. That is writ petition.
So now court is to dispose of 3 writ petition.
3 writ petition. One is
I'm only appearing in 1 writ petition.
One of the last writ petition that was filed in the year of 2023. That is, my lord. My lord, if one is disposed of, every will be disposed of.
Not necessary, not in all cases. The point.
Okay, 3 writ petition. WPA 1063, WPA 166, and
9 application.
Number 1 is our matter. Number 1 is our matter. I'm really concerned about that. I cannot take the responsibility to the others. And I cannot, I'm with all respect, I'm differing with him. The 1 petition is rejected, that means the other also rejected. It can't be.
My lord, subsequent writ petition, that is, my lord, 12723 of 2023. That was dismissed, that writ petition. My lord,
but one thing is common, Mr.
My lord,
all 3
latest writ petition was dismissed.
All 3 writ petition, one thing is common, that is your common advocate on record.
And this matter also, my lord.
So you are not taking responsibility of other 2 writ petition? No. Therefore, other 2 writ petition are dismissed. Other 2 writ petition are dismissed. For want of prosecution, so dismiss as not.
If the
My lord, for a moment, kindly see page 33, my lord.
And what is the difference? Dismissal default. It is not on minor nose. It is not registered. But
does not want to proceed with the writ petition.
Let them, my lord.
And accordingly dismissed as not present.
For a moment, my lord,
I can be prevented to approach your lordship with the grievance. Well, this is the positions.
As Mr. Nondi much earlier I stated.
And my lord, just
my lord, yes.
days ago.
What very interesting, my lord.
My lord,
Please,
for a moment, my lord, kindly
just a
see
minute,
page
just a
33
minute, my dear.
of my office.
Okay, I'm coming to you. Yes.
Kindly see.
I'm coming to you. Let the yes.
The writ petition which he referred.
Remove the
writ petition
confusion.
of 23.
Writ petition of
23.
23.
2023. Number is 12723.
Yes.
Shrimati Gopal Chakraborty and others.
No, you come.
That is already dismissed.
আরে বাবা বলছি দাঁড়া না ব্যস্ত হচ্ছিস কেন এই that shows you have no case. Why are you so excited? রাজসাহেব তো চলে যাচ্ছেন না সবাইকে তো সুযোগ
Writ petition 10263 of 2007.
is my petition.
WPA 166 of 2022 and WPA of 52 of 2022 have been clapped together, or most probably direction was given for analogous hearing.
No, he referred the judgment of another writ petitions. The man, it is already decided. That was filed in 2023.
Yes.
And my application in 2021.
Decided by a coordinate.
Same writ petitioner. Same writ petitioner filed the writ petition challenging my lord the same issue in 2023. That WPA number 12723 of 2023. Gopa Chakraborty versus Union of India. And my lord, considering everything, that then Honorable Justice Vivek Chaudhary dismissed this writ petition. So, my lord, what my learned esteemed friend is submitting regarding that Honorable Justice Dipankar Datta, that is square feet or square meter, that is already marched with the order of the Honorable Justice Vivek Chaudhary. Everything has been completed.
How?
My lord, kindly see
This
the
order was passed in this writ petition. It is still pending.
My lord,
It can only
writ petitioners are the same. For this reason,
that would be a different question. That is
for this reason, my lord, I am
that would be a res judicata or constructive res judicata.
my lord,
The merger or doctrine of merger is totally
yes, my lord.
different.
For this reason, kindly see, my lord, the
With all
order
respect, my
order
lord,
of this honorable court.
constructive res judicata, my application is earlier. Since it's the later one, so whether at all that particular things will apply in my case, that principle of as it is rightly formal losses, my lord.
The res judicata, when it was filed, it is immaterial. When it was decided, it is immaterial. A previously sued,
correct,
previously instituted action.
I admit. But
decided earlier.
Here, my application not with regard to the entire merit. My application only for corrections. If really that is so, it has not. Suppose today, my lord reject this application. I've got no other already but to enter into the merit of the writ petition. Suppose if it is allowed, then everything will be solved. Because there is no default on my part. I've been paying. Since they refuse to accept, I'll pay. That is all. That goes to the root of this case. Otherwise, there
No, actually, as on date, you have been evicted.
That's true, my lord. Forcefully, illegally.
They have taken possession of the premises.
That's true.
Now there is no scope of passing any interim order. Even if that order is modified to the from square feet to square meter, it will not serve any purpose because you are not in a position as on date. Yes.
May I be permitted to
So
interrupt?
allow the court to dispose of the entire writ petition.
May I allow?
Yes, yes.
Yes. No, my lord, I could have understood that well. For other reasons, I have been evicted. I'll place from my own petition. They say, since you have not complied the order of justice, Doctor, that is why we are evicting possessions. So once it is found by lordships, no, this is wrong. This is wrong. Then if it is so, why did we accept for last 14 years? From Mr. Banerjee's time? 14 years they accepted that rate of 10,000 per square meter. Suddenly after 14 years, they woke up on the slumber. No, I'll have to pay it. And see the amount. It's impossible. No sensible person can accept that 12 for 150 square feet. That means come to 12.5 lakhs per month.
That means if your contention is accepted, that your contention is the let the petition pending for indefinite period. Just court should correct that from square feet to square meter and give a declaration that they are not violated any terms and condition of the agreement and there is no violation of the order So eviction back, you reinstate them.
No, no,
Huh?
consequences
And
are-
allow them to enjoy.
No, no, consequential part. This is-
Enjoy the premises.
Even your lordship did not pass that order, it's a consequential. Because I could have understood their action based on violations. If for independent cause of actions, I'm out. But their actions is based on the violation, non-compliance with this order. One, if it is found, my lord can reject it, no problem. My lord can allow it. But if your lordship say no, probably you are right because I cannot believe that 12 for 150 square meter by square foot. 12.5 lakhs per month on this store. And that's why they are only for 14 years. So once it is found, my lord, that 12 is some mistake, corrected. All consequences part will automatically come. If for other reasons they evict me, that's a different thing. But if that only for that reason I am evicted, that means that is illegal. Is it believable, my lord? And their own council communicated per square meter. I'll annex in my petition, I've stated all these things. Kindly appreciate it. And they have not been denied. If it is uncontroverted, 93 Supreme Court violence was better than my lord, that means they have accepted. So how they can?
Whether any written agreement here?
Yes.
Written agreement is so the written agreement. Per square foot or square meter will be recorded.
Very rightly, my lord asked this question. Can 3 page 24. Very rightly, my lord put this one. It is impossible.
Way. You find.
পড়ে যাবে আপনার ছেড়ে দিন
No, no, fine.
না তার জন্য না ছেড়ে
Ask
দিন
your junior to come with a compilation.
আপনার আরে
Either come with a paper book or come with a compilation.
My lord,
You find can আবার আপনি গুনছেন কেন?
compilation ঠিক আছে তাই করুন হ্যাঁ আই এম সরি মাই লর্ড সাজে
Have you got the copy? You show.
My lord,
for the agreement.
My lord, why they are hammering on that point? Because my lord, nowadays,
because you have given me out and our livelihood is involved. You have driven me out illegally. No, kindly see, in spite of he communicated.
I'm sorry, what is smart? Kindly see. Square meter.
That's why they communicated by letter. My lord, just
then my lord, kindly see the entire agreement first.
It is an agreement.
No, my lord, kindly see.
Why just entire agreement? My lord, put the one question. Why it is mentioned?
আপনি আমাকে বলতে দেবেন না
তুমি যদি এলোপাতাড়ি কথা
আপনি বলে নিন তারপর আমি
Mr. Ghosh, I do not need the Gandhamata Parvat. I need Visallokarani.
In the reply,
whether square meter or square foot.
That's all. From the agreement, it appears square meter.
The court is making an inquiry whether the rent was agreed upon to be paid per square feet or per square meter.
Absolutely correct.
Yes.
And they communicated.
This question.
Now, kindly see the letter. Kindly see the letter. Just their council's letter. Communication.
Square meter.
So, my lord, may I say, my lord?
So, whether you have evicted them on the plea that they have not paid rent as per the order passed by Justice Dipankar Datta as his lordship then was.
Yes.
Have you evicted?
Yes.
My lord, may I?
So it is apparent that it is square meter. Yes. Bol. Tell.
My lord, before that, my lord, one thing, just one. I am really tempted, since my lord is very kind enough to give everybody a full opportunity. That's why, well, I'm taking the advantage of that. I must finally confess. But I just had one judgment, my lord. Very interesting, the power of the High Court. Probably in one case I argued with losses, I cited, but I cannot remember. As my lord knows, my lord, there's a basic difference between Article 32 and 226. Because Article 32, my lord, foreigner cannot.
Yes.
Or Article 19 only. Article 19 is a fundamental right, but Article 14 is not the fundamental right, which is fundamental chapter. Because even a foreigner can challenge action under Article 14 of the Constitution. So it can be fundamental right, fundamental chapter. Power of your Lordship, Justice Martin, I had a privilege to appear before Justice Martin's very first day. This is not in that case. With Senior Chandrachud, he was the Chief Justice, Justice Thakkar and Justice Martin. And I got an opportunity to argue before them in one case. The very Just like your lordship got the smiling face and giving all his intelligence. All right, tell me what you want to say. Kindly take trouble to see this judgment, my lord. Power of your lordship, my lord. We are taking very lightly. It's not so easy. High Court power on Article 26 is absolutely different. Well, paragraph 19, I need not read the entire judgment. That will create some. Paragraph 19, just above the paragraph 20. It's very interesting.
Yes.
Have you got it, my lord? Just above the paragraph 20.
Yes.
End of the paragraph 19. It starts from, I need not read the entire.
To remit the
in Hallsbury laws of England. Have you also got it, my lord?
Yes.
Hallsbury, England. 4th edition, volume 1, para 89. It is stated that the purpose of an order of mandamus is to remedy defect of justice, and accordingly it will issue to the end that justice may be done in all cases where there is a specific legal right and no specific legal remedy for enforcing the right, and it may issue in cases where, although there is an alternative legal remedy, yet that mode of redress is less convenient, beneficial, effectual. Then paragraph 20. There is thus no doubt that the High Court in India exercise their jurisdiction under Article 226 have the power to issue a writ of mandamus or writ in the nature of mandamus or to pass order and give necessary directions where the government or the public authority has failed to exercise or has wrongly exercised the discretion conferred upon it by statute, a rule, or a policy decisions of the government, or has exercised such discretion malified or in irrelevant consideration, or by ignoring the relevant consideration and material, or in such a manner as to frustrate the object and conferring such discretions or the policy for implementing which such discretion has been conferred. In all such cases, and in any other fit and proper case, High Court can, in the exercise of a jurisdiction under Article 26, issue a writ of mandamus or writ in the nature of mandamus or pass such order and give discretion to compel the performance in a proper and lawful manner of the discretion conferred upon the government or a police public authority. And in a proper case, in order to prevent injustice resulting to the concerned parties, the court may itself pass an order or give this direction which the government or the public authority should have passed or given had it properly and lawfully exercised the discretions. Well, the power of the High Court is supreme, my lord, there's no doubt about it. Because Supreme Court is enjoying one power, Article 142. I remember in one case I was appearing with Justice Korean Joseph. My lord, Justice, then other side, my lord, he said, no, there is no vacancy. Look, have you gone to the Constitution, Article 142? Other counsel says, my lord, I know that. Please don't allow to open our mouth too much. Next, after fortnight, he prepare all the 62 candidates' appointment letter. I know how to tackle the situation. You must give it. So that is the only privilege of the Supreme Court. Other than that, Article 226 is enormous power. I had a privilege to see so many high courts of throughout the world. At the 80 countries have trouble. Wherever I have gone, I tried to find out the legal process. But our high court, I am not praising the fact. Unfortunately, we are overpopulated. That is the problem. Our high court, our constitution is really very, very, very effective, my lord. So let's kindly see lots of powers. No, law doesn't mean to be mere theoretical abstraction. It is an instrument to have the justice and justice for all. So, my lord, what's wrong my client has committed? Kindly, it's the abstract proposition. My lord can ask them, are we in a position to pay that amount, Mr. Counsel? 12 lakhs and half? If I provide you with 150 square feet in metro, in
I cannot recollect the judgment. High the power, high the responsibility. So much power you will get, so much responsibility you will have.
Why not kindly appreciate one aspect? Responsibility to do the justice. Power never misused. Wrong. We are trying.
On my judgment, I stated that we in the jurisdiction we started our journey that we have the arm to reach wherever injustice is found.
That's true. That's true, my lord.
Our arm.
My lord, kindly see the way
over the year we have developed that concept of self-restraint.
Kindly see.
And many things, many act has come.
Yes.
Many act has come.
Yes. My lord,
judgment has come.
Of course.
And this
When
power is to be exercised judiciously,
well,
always.
that's true, but question is this, my lord, there's a basic difference between these two determinations and civil determination. That's why, my lord, whenever we move a writ application, my lord, in civil matter, as my lord knows better than my lord, plain, then written statement, the affidavit chief, then cross examination, disclosure documents, something. But in deed matter, there is a scope. If you rely on certain document, you must include in all the petitions. Otherwise, there is some sort of problem. Court will not come to this school. But when I joined, my lord, not much, only 52 years back, then my lord, read approach is quite different. Little bit rigid. As it is found by losses, my lord, so many acts was born. Need of the society, power of the High Court, power of the Supreme Court, always to protect the interest of the people at large, to do the justice. It's enormous power, my lord. There's no doubt about it. It's a prerogative, special prerogative. So naturally, consciously, no judge, it's my belief, misuse the power. In deciding, the mistake may be there. Other day I was arguing on a division bench. Very well, you say how the trial court pass the order. And that judge will never come.
Okay, that would be taken care of and addressed. Now, if considering all this aspect, this court pass order, specific this court hearing your junior, that all the writ petition along with the pending application, all remaining pending applications shall be heard. Now, I cannot act contrary to my own order.
No, I'm not saying that. That means my lord did not turn down.
Hence, now, if you want the court now to rectify that thing, that the square foot to square meter and a declaration that there was a mistake, it was not factually correct, it would be square meter. So their action to evict you on the ground that it has not been, that payment has not been made as per the order is wrong. So reinstate them. Without doing so, you press the entire writ petition. That would be better. Because of the fact, if today I pass that, you reinstate them. Tomorrow I pass a contrary order, that would be.
No. Sorry to interrupt, see. Under what circumstances my lord is passing today's order? Tomorrow, my lord, or day after tomorrow, in the main matter to be heard, if it is found by your lordships, Mr. Banerjee, reason for which I directed them to reinstate you. You have been reinstated. But now I am hearing, after going to the writ petition, I found you cannot stay over there. Certificate. That can always be done.
Then the question of compensation and anything will come, multiplicity of proceedings, then further complication, and hence considering all order, it was directed that let us here, let us place consider the main writ petition.
Well, one thing, my lord.
Court have understood.
No. One thing, my lord.
Just had this order and somehow enter into the property.
No.
Then for another 18 years, it is pending for.
My lord, kindly see the
2007.
Kindly see the reaction of Justice Dotto. For 14 years, they didn't file their affidavit. Kindly see the remarks, Justice Dotto. Again, I'm praising.
Okay.
It is
it was filed.
No, one thing, my lord, had it been a case.
The petition was filed in 2007. Thereafter 18 years. That means
they are responsible.
1.5 decades.
They are responsible. Justice Dotto remarks. Justice Dotto in the order remarks that you, that material, you are responsible. Why did you not file the affidavit? Kindly see. The order never says.
Okay. You prepared one list of dates. That would be better.
That will do.
In one page, you just write, I stated you. Yes. Can 1 was filed for this person. Can 1 application for state. That would be sufficient for us. Can 2 substitution. That would be and writ petition number 1. I am giving example. Writ petition number 1 died on certain side. It is that legal errors. We are not required to touch the application. Can 2 for interim order.
Absolutely.
Restraining the respondent from doing such and such. Purpose will be served in this way. And you filed a compilation. As well as. It is the agreement. Thereafter we inducted. Thereafter such and such. This order will pass.
I'm grateful.
That would be
I'm grateful.
Beneficial for all of us. It would be really not possible, difficult to handle. Heard the learned senior advocate, heard Mr. Banerjee, learned senior advocate appearing for the
Whereas this petitioner, my lord Munna Prasad, my lord, was not a internal candidate of DVC. Now, my lord, a selection process is organized by DVC. That is dated 10th of May 1991. Lordship has seen that advertisement. Post was for dozer operator grade 3. Now, my lord, they interviewed the post for dozer operator grade 2, but took selection process for dozer operator grade 3. Now, my lord, though, my lord, Gopal Rai, Trilochan and Shaheen Akhtar were internal candidates, and this petitioner was an external candidate, all of them, my lord, participated in the same selection process, which was based on the advertisement dated 10th of May 1991. Now, if your lordship takes up internal page 5 of their affidavit in opposition, paragraph 6. Now, my lord, their contention is the above mentioned writ petition was filed by one Gopal Rai and two others on the ground that since they are working as casual workers in DVC, they were seeking a direction to DVC to absorb them as dozer operator with regular scale. They were also seeking a direction to DVC that since their pay was comparably low compared to the pay drawn by regular employee, they prayed for making difference in payment of the difference in wages paid to them, and those paid to regular employees similarly situated and performing similar duties at least from the date of interview, that is 4th December 1991. So, in my case, the date of interview was 15 December 1991. In case of Gopal Rai and others, their date of interview was 4th of December 1991. So, irrespective of the fact that whether I am an external candidate or an internal candidate, Gopal Rai and others and this petitioner, they all participated in one common selection process, which was held pursuant to the advertisement dated 10th of May 1991. Now, thereafter, what had happened was Gopal Rai and others, they were not being granted appointment to the post of dozer operator grade 2. They took out a writ petition before this honorable court. This honorable court direct.
Keep the mic away.
Lordship.
Yes.
But I shall place it at But this honorable court directed that Gopal Rai and others, they should be granted appointment to the post of dozer operator grade 2, and all their arrears should be granted on and from 1991 as per their prayer, which is 4th of December 1991. That order was passed in 1995. Now, thereafter, the DVC authorities challenged that order, did not comply with that order, there was a contempt. Now, my lord, the contempt, my lord Justice Ajay Nath Rai, as his lordship then was, issued a rule of contempt, saying that stringent action will be taken if this order is not complied with. That order was challenged before the Honorable Division Bench. Honorable Division Bench did not refuse, my lord, did not interfere with that order. DVC authorities went up before the Honorable Supreme Court of India. Honorable Supreme Court directed the DVC authorities to comply with the order passed by the learned single judge. And pursuant to that, my lord, the DVC authorities before the learned single judge complied with that order, and my lord, Gopal Rai and others were all given their benefits, including appointment to the post of dozer operator grade 2, my lord, on and from 4th of December 1991. So, my lord, I say that, my lord, this writ petitioner, my lord, he also participated in that selection process on 15th of December 1991. He was not appointed to the post of dozer operator grade 2. He preferred a writ petition before this honorable court. This honorable court in that writ petition directed that Gopal Rai, Trilochan and Shaheen Akhtar should be made a party respondent to this writ petition. That writ petition was heard and disposed of. Pursuant to that, my lord, in the year 1999, this writ petitioner was not even appointed to the post of dozer operator grade 2. He was granted appointment to the post of junior technician dozer operator. Well, from junior technician dozer operator to go to the post of dozer operator grade 2, I had to take promotions and reach the post sometimes in the year 2005. So, my contention is that if Gopal Rai, Trilochan Singh and Shaheen Akhtar, who have participated in the same selection process, can be given appointment to the post of dozer operator grade 2, and in spite of the fact that they also did not render services in that said post for that amount of period, if they can be granted, my lord, the difference in wages, my lord, why should I not be granted? That is my case in short.
Their defense is that in your writ petition, direction was given to appoint you to the post of dozer operator grade 3. You accepted the same. You have not challenged that order. That means that order, assume a
But accepting that I am
it is binding. The order is binding upon you.
Absolutely.
You have not raised this point.
Absolutely.
Subsequently, you raised this point.
But if that is also correct, kindly sees the post in which I am granted appointment. Had that been a case in which the selection is for dozer operator grade 2, I am appointed in dozer operator grade 3. I am interviewed for dozer operator grade 3, but I am joined in the post of junior technician dozer operator. But I admittedly did not challenge it. I got my appointment in 99 in the post of junior technician dozer operator. From junior technician dozer operator to go to the post of dozer operator grade 3, it took me 6 years time. I got that appointment in 2005. So my contention is that if I was appointed in 1991, they have interviewed me for dozer operator grade 3. They should have appointed me in the post of dozer operator grade 3. They appointed me as dozer operator grade 3 in the year 2005, that too by way of regular promotion. So if my cadre post was dozer operator grade 3, assuming my learned friend is correct. So appointment interview is for the post of dozer operator grade 2. Selection interview is for advertisement is for dozer operator grade 2. Interview is for dozer operator grade 3. They should have appointed me in the post of dozer operator grade 3. They did not do it. They appointed me in 1999 after 8 years in the post of junior technician grade 3. In the pursuant to an order passed by this honorable court. 2005, I am brought back to the post where I should have been in 1991. So Gopal Rai, Shahin Akhtar and Trilochan Singh, they were claiming for similar benefits as to why we should not get it from our date of interview, which is 4th of December 1991. But my contention is similar, that why I should not be granted my interviewed post since 15th of December 1991. Well, that is my case in short. If your lordship takes up my affidavit in reply.
Appointed in 1999.
I was appointed in 1999 in the post of junior.
You are now agitating this point in by filing a writ petition in 2013.
Yes.
After 14 years.
No, my lord, because only thing is, my lord, kindly comes to one paragraph of my writ petition. My lord, internal page 6 of my affidavit in reply, paragraph number 12.
Internal page 6, paragraph number?
My lord, internal page 6, Roman 12.
Yes.
I further say that I had applied for the post of dozer operator grade 2, which is a higher post. I had applied for that post. Interviewed and selected for the post of dozer operator grade 3, which is a lower post, and appointed for the post of junior technician grade 3 dozer operator, which is a much lower post, which is illegal, highly illegal and arbitrary act on the part of the respondent authorities. I further say that based on the appointment letter dated 12th of July 1999, I have served in the post of junior technician grade 3 dozer operator till the year 2005, and thereafter I was promoted to the post of dozer operator grade 3, which is the next higher post. From the post of dozer operator grade 3, I was promoted to the post of dozer operator grade 2 in the year 2011. So my lord, if I am reaching the post for which I was interviewed in 1991 in the year 2011, but I have filed this writ petition in 2013. But I have annexed the advertisement, which is a part of the same reply.
Yes, page.
Well, it kindly comes to the advertisement annexure R2 at page 13. Well, in their opposition, they have not at all denied this. comes to 6, page 17.
All written in Hindi.
My lord, I have the translated portion copies thereafter. Kindly comes to page 17.
17, yes.
Kindly sees Roman 6, post number 91 of 18. The post is dozer operator grade 2. Total vacancies is 10. Now kindly comes to my...
They even did not give you appointment even in compliance with the order of the writ petition
Yes.
by you.
Yes.
The court coordinate bench directed them to give you appointment to the post of grade 3.
My lord, yes,
They have
grade 3.
given junior technical.
Junior technician, dozer operator. That is the post in which I am initially appointed from in the year 99. Well, to reach the post for which I was interviewed, it took me 12 years to regular promotion. And thereafter, my lord, in 2013, my lord, I have filed this writ petition before this honorable court. My case is that, look, 2010, my lord, similarly in case of Gopal Rai and others, they have adopted the same principle. 4th December 91, Gopal Rai and others are appointed. Writ petition is filed by them in 95. That writ petition, my lord, goes before the learned single judge, division bench, Honorable Supreme Court, back to the learned single judge, and they comply with the order of the learned single judge in 2010 or in 2011. So, my lord, as soon as Gopal Rai gets these benefits, my lord, I feel that I am similarly circumstanced. I should also get this. And thereafter, my lord, in 2013, I filed this writ petition before this court. So, my lord, my contention is I am absolutely similarly circumstanced. My lord, my learned senior friend has relied upon a decision on the last day. My lord, I am thankful, my lord, I too shall be, my lord, relying upon this decision. My lord, that is reported in 2022, volume 13 Supreme Court cases.
Yes, yes.
Yes. But kindly comes to the paragraphs which have been relied upon by my learned senior.
14 to 18.
But yes, perhaps relied upon paragraph 17 and 18.
18.
Yes.
Yes.
2022 কত ছিল রে? কোথায় গেল? এই যে। Now kindly comes to paragraph.
Well settled.
Yes. So my lord, here the language. Yes. But I shall be only relying upon paragraph 17. The question as to whether a classification is reasonable or not is to be answered on the touchstone of a reasonable common man's approach, keeping in mind the avowed object behind it. If right to equality is to be termed as genus, a right to non-discrimination becomes a species. When two identified groups are not equal, certainly they cannot be treated as a homogeneous group. But I say I am a homogeneous group with Gopal Rai and others. Because, my lord, what Gopal Rai, the only distinction between me and Gopal Rai is they were internal candidates, I am an external candidate. But, my lord, as soon as the selection process comes into picture, my lord, we all are starting our race from, my lord, from the same line. There is no distinction in the selection process that you are an internal candidate, so you would be getting a much an advantageous footing. You are an external candidate, you will not get that. And there is nothing mentioned in the recruitment procedure given by DVC that internal candidates would have a greater advantage compared to that of the external candidates. Nothing. So, my lord, whenever the selection process starts based on the advertisement dated 10th of May 1991, my lord, we all start from the same line. So, there cannot be any discrimination. We all are in the homogeneous group.
My lord, only I invite your lordship's attention.
My lord, reply.
Whole statement is my lord, misleading and my lord, not based on material on records, my lord. I invite your lordship's attention, my lord, to the writ petitions as page 20A. What?
So 28.
Page 20A.
Writ petition.
Writ petition. It is their order. at page 20A. Because typed copy 20A.
Oh, page number, no, it is internal page. You say internal page.
Yes, internal page. No, running page possibly.
But first is the original order, then there is the typed copy.
Type copy. Type copy 20A as not type copy internal page.
Internal page 4.
Internal page 4. Okay. Yes.
Yes. The above writ applications is filed by petitioners 5. There are 5 petitioners. In number, claiming release for appointment to the post of dozer operator grade 3. Application for which you are invited from eligible persons through advertisement number 91/81, said to have been published in the daily newspaper Telegraph dated 5th May 1991. In terms of this
Yes. Now you come to that annexure. You
yes, my lord. In the affidavit in reply, my lord.
In the affidavit in reply page.
Yes, my lord. In the affidavit in reply, for the first time, my lord, they disclose an advertisement, my lord.
It is your advertisement. You issued.
No, my lord.
Mr. Tarafdar, it is your document.
My document.
Now, rather, it is appearing you are taking advantage of their what I say, their failure to mention the case properly.
No, my lord.
Present their case
No,
properly.
my lord. No, my lord. Because the facts recorded by.
Okay.
Yes,
okay, it is the court of record.
Yes, yes,
Huh?
yes.
Now, court of record asking you, you say for which purpose you initiated the selection process.
My lord, this was.
You produced the same.
Yes, my lord. This was disclosed.
You produced the original advertisement.
Yes, my lord. This was disclosed for the
original advertisement is one type of a contact.
Yes, my lord.
Offer.
Yes, yes.
Is that offer is accepted, then it would be a concluded contact.
Yes, my lord. Yes, my lord.
You cannot deny.
Yes, my lord.
So you are offering that if possess this qualification, apply.
Yes,
if you found him successful, find you successful, you will be given that job.
My lord, then also, my lord, I
yes,
my lord. I'll give reply, my lord. Your lord's queries, my lord.
Yes.
Firstly, my lord, first, my lord, I have to ascertain, my lord, whether two advertisement is different or not. Because the court has recorded that pursuant to the advertisement issued on 5th May 1991. They are saying 10th May 1991. So I have to ascertain, because since it has been recorded by a court, this honorable court, my lord, so therefore I cannot, my lord, say that this is not correct, my lord, because it is presumed to be correct. Any judicial findings is, my lord, admissible in evidence and presumed to be correct, my lord. So that should be proceeded on the basis that this was done on 5th May 1991.
Observation of the fact.
Yes, my lord. Then second point.
If it is found that this observation was not actually correct.
Yes. Then I will give reply.
There was a mistake of fact.
Yes, my lord. Then, my lord, I'll give reply, my lord. I brought the judgment, I'll give reply, my lord.
Yes.
Suppose, my lord, if your lordship, my lord, appreciate that, my lord, because the background, my lord, on the basis of which how the Gopal and these two other sign actors and which was given appointment, I explained on the last occasions, my lord, because they initially joined, my lord, as a dozer cum operator, my lord, and they continued, my lord, for 4 years, my lord. My lord, their appointment was not made, my lord. Their service was not regularized, my lord. In the meantime, advertisement came out, my lord. They moved a writ petitions before the honorable court, my lord, asking for the payment of salary on the basis of equal pay for equal work. That means those who are already appointed as a dozer operator, like the same salary should be extended to the petitioner and to absorb them in the permanent post, my lord. That was their prayer. That writ petitions was heard, my lord, and directed to give appointment, my lord. In the meantime, my lord, 1991 interview took place, panel was made, my lord, but appointment was not given, my lord. In pursuant to the order of the honorable court, these 3 persons, my lord, were giving appointment, my lord, in 1991, my lord. And those persons, my lord, they were giving appointment, they are the fresh candidate. Because they are the not only insider candidate, they discharge their duties and responsibilities for more than 5 years as a dozer cum operator. So that is why, my lord, that the court directed to absorb them, my lord. Pursuant to that went up before the Supreme Court. And so many contempt applications was initiated, my lord. Before Supreme Court, ultimately, my lord, pursuant to the order, they were given appointment, my lord. And this incumbent were giving appointment in 1997, my lord. In 1999, my lord, pursuant to the interview held in the year 1990. And what they have claimed in their writ petition, the same benefit should be extended to them. What is the benefit? That those three incumbent, they were extended benefit. They claimed that from the date of their initial absorption, but at least from the date when the interview was held. So court accepted the date when the interview was held. So this is two distinguishing feature. It is not the case that they have prayed for those are 2 and they were giving appointment those are 3. This is not a case, my lord. For the first time, my lord, in reply, they have come out with this case, my lord. That I will also give reply also to that extent, whether in the law, whether it is tenable or not. That I will also explain, your lordship, my lord. So this is the position. Distinguishing feature is this, my lord. My lord, since my lord, as your lordship is my lord, well, my lord, aware and should appreciate, my lord, that since it is a writ petition like a civil proceedings, my lord, there is a scope, my lord, for discovery of evidence and all this, my lord, even after filing the pleadings. That is plain and written statement. Since in the writ petition there was no such scope, that is why Supreme Court has laid down a law, my lord, in 1988, that in a writ petitions, all the documents on the basis of which his right is substantiate, they should annex all these documents in the writ petition. So pleadings always, my lord, petition and opposition, not rejoinders and others. So in the petitions, nothing has not been said. I am, my lord, relying one judgment before your lordship, my lord.
Another judgment, ongoing.
Yes. No, my lord, because what an interesting point had been raised by your lordship, my lord, then it is my duty, my lord, to satisfy your lordship. It's a question of law. Yes. It is reported in 1998 4 SCC 534.
Yes, what is the proposition?
Yes, my lord, paragraph 13.
Yes.
Paragraph 13, at page 543.
Yes.
In our opinion, because it starts from in our opinion.
Got it.
In our opinion, when a point which is ostensibly a point of law is required to be substantiated by facts, the party raising the point if he is the writ petitioner, must plead and prove such facts by evidence which must appear from the writ petition, and if he is the respondent, from the counter affidavit. If the facts are not pleaded, or the evidence in support of such facts is not annexed to the writ petition or to the counter affidavit, as the case may be, the court will not entertain the point. In this context, it will not be out of place to point out that in this regard, there is a distinction between a pleading under the Code of Civil Procedure and a writ petition or a counter affidavit. While in a pleading, that is a plain or written statement, the facts and not evidence are required to be pleaded. In a writ petition or in the counter affidavit, not only the facts, but also the evidence in proof of such fact have to be pleaded and annexed to it. So the point that has been raised before us by the appellant is not entertainable, but in spite of that, so and so. So this is the principle laid down by the Supreme Court. So in the writ petition, what is the prayer of the writ petitions, my lord? I once again invite your lordship's attention, my lord, to the prayer of the writ petition.
Yes, I have seen.
Yes, my lord. Then, my lord, in this background, my lord.
Writ petition not happily drafted.
Yes, my lord.
Yes.
Then I have demonstrated your lordships, because there are two different distinguishing features, my lord. Because the classifications is based on, my lord, two principles, my lord, two interests, my lord. That it must be founded of intelligible differentia, my lord, based on the one group and that of the other group who have been left out, and there must be a rational nexus between the classifications and subject ought to be achieved by such classification. This two interests has to be satisfied in case of any classification. So that is why, my lord, I explained on the last occasions what is the two distinguishing feature to extend the relief as they prayed for in the writ petition. They only prayed for in the writ petition to extend the same benefit to us, my lord. What benefit was extended to us? In the same grade 3, but with effect from 1991. His appointment was given with effect from 1999. Where he has given appointment?
And Gopal Roy?
From 1991. Why Gopal Roy was 1991? Because they are the insider candidate and they discharged more than 6 years as a dozer cum operator. That is why, my lord, they filed a writ petition. Yes, my lord. And this Gopal Rai also appeared, my lord, pursuant to the advertisement issued on 5th May 1991, my lord.
5th May?
1991.
Same.
And he is saying the 10th May. I'm coming to that.
Okay. I have got your point.
Yes, my lord, I'm coming to that.
I have understood the stand of the DBC.
No. Yes, yet I have not finished. Yet I have not finished, my lord. Because say, my lord, they are persons, my lord. Those who are, my lord, discharging their duties and responsibilities as a dozer operator, my lord, for the last 6 years, my lord. They were not absorbed. They were not extended in their payment of salary like the regular employees. They came up before the court, asked for their absorbment and extensions of such benefit which was given to the regular candidate. So thereafter, in the meantime, interview was held in 1991. Then they claimed ultimately, the court accepted their claim, and while fixing the date of his appointment, court fixed the date of appointment from the date of interview, because they said that at least from the date of initial appointment, if not, at least that should be given from the date of interview. So this feature, this aspect of the matter is completely absent here, because things are similarly situated, should be treated alike. That's the requirement of Article 14. So two things are not similarly situated. They are the direct employee. So that is why that distinguishing feature, Article 14, will come into play. And my lord, they have not committed any wrong. Those appointment was given pursuant to the order of this honorable court, which was went up to the Supreme Court. So this is the positions of that three. Now, my lord, in this background, my lord, they filed the affidavit in reply, my lord. In the reply, they said that, yes, I applied against the grade 2, but I was given appointment grade 3. Same person is stating in the affidavit. I invite your lordship's attention at page 7, paragraph 12. I further say that based on such appointment letter, dated 12 July 1999, I have served the post of junior technician grade 3 till the year 2005, and thereafter I was promoted to the post of dozer operator grade 3, which is the next higher post from the post of dozer operator grade 3. I was promoted to the post of dozer operator grade 2 in the year 2011, and from such post, I was promoted to the post of dozer operator grade 1 in the year 2017, and ultimately promoted to the post of dozer operator in the year 2022. So all the promotions he has accepted. My lord, there is a law, my lord. There is a doctrine, my lord, of waiver and acquiescence, my lord. If
I have understood.
Yes, my lord. If somebody
I have understood.
Yes,
admission. Okay.
Yes.
It is.
Yes.
It is conduct of a litigant during carriage of proceedings.
Yes.
Admission.
Yes.
Waiver.
Yes.
Acquiescence.
Yes.
All things.
Yes.
It is conduct.
Yes.
Now I can ask whether admission can be stated to be a conclusive proof of a fact.
Admission to what extent, my lord? That
Any admission.
Acceptance.
What is the effect of admission?
My lord, under
I'm asking.
Yes, my lord. Under the Evidence Act, my lord, admitted fact need not be.
I'm also making
admitted fact need not be proved.
Yes, my lord. Admission generally stop that person from re-agitating the thing or from denying the fact.
Yes, my lord. From denying that.
Admission has a right. It is not exclusive proof and conclusive proof. I am giving an example. Don't take it other ways. Today, I file a suit against you.
Yes.
Seeking a decree of declaration.
Yes.
That Victoria is mine. You entered your appearance,
yes.
Filed your written statement, admitted.
Yes.
Whether tomorrow shall I be owner of Victoria? No.
No.
So admission does not cannot.
No, my lord. This is that
admission cannot give title.
Yes, my lord.
First.
Yes.
But admission is also not a conclusive proof.
My lord, this is my
okay.
Yes, my lord.
So admission, waiver, it is carriage of pay. If court finds
Yes.
that truth, there is a conflict in between truth and admission and such, this thing which was done by a party to the proceeding during carriage of proceedings. Now what part will prevail? And what court will accept?
Yes.
Truth
Yes. Yes.
or this conduct?
Yes. Then Milord. Yes, Milord. Then Milord.
So here truth is that
because the
you initiated selection process to fill up the post of dozer operator 2. In that selection process is invited in-service candidate as well as the external candidate that you participate.
No, that was
For
the basis
which
of
post
advantage.
they offered their candidature? Dozer operator 2.
No, Milord.
Admitted. 2.
No, Milord.
Now you forget about whether they have admitted, whether they have accepted, all their subsequent conduct.
Milord, that is not the facts, Milord, because for the first time they have brought this document. Even if, Milord, I will show, Milord, I will, Milord, get inquiry, and Milord, I'll show, Milord, that this appointment was given pursuant to the advertisement published on 5th, Milord, October 1991, Milord. Everywhere it was recorded up to Supreme Court, Milord. So there is no, Milord, scope, Milord, to deny these facts, Milord. It's a recorded facts, judicial records.
Mr. Das and Mr. Tolga, contempt proceedings was initiated by whom? Gopal Rai?
Gopal Rai.
Or petitioner? Gopal Rai.
Gopal Rai.
Oh. Then, Milord, then second reply I am giving, Milord. Milord, this all waiver and acquiescence, Milord, is the exceptions of the concluded contract, Milord. Because this is what is the waiver, Milord? Conscious abandonment or relinquishment of non-legal right. Yes, he might have a right. He consciously abandoned it, Milord. Because these long course of time, Milord. So that I will show before your lordship, Milord. There is a distinction between stopple and waiver, Milord. So here is a waiver, Milord. He waived his right, accepted the appointment, accepted the promotion. He served all these years. Now court cannot say
that
again
you taking decision in their contact. You are taking defense and you are seeking justification of your conduct in their action.
No, Milord. No, this is Milord. My contention is this: those persons who are appointed, Milord, on the basis of the advertisement published on 5th October 1991, that was never, Milord, denied. If so, Milord, so completely the two different aspects. What they have prayed for in the writ petition. Come, your lordships, come to the writ petitions. You cannot
I have got.
Cannot go beyond of the writ petitions.
Yes. So hearing conclude. Yes. Judgment is up. Yes. Mr. Das and Mr. Das appearing.
For my learned senior friend, Your Lordship, Mr. Loki Kumar Gupta and Mr. Vikas Ranjan Bhattacharya is happening in this matter, Your Lordship. Mr. Loki Kumar Gupta is not well, Your Lordship, and Mr. Bhattacharya is out of station, Your Lordship. I am praying for any day after 15th of August, Your Lordship. Any day. It's a request from Mr. Bhattacharya, Your Lordship, any day after 15th of August.
That matter, the constructive res judicator.
And you didn't agree to accept their proposal. You are not ready.
The proposal is something that you will be getting minus something.
Okay. At 2 p.m. I will say.
Constructive res judicator, may I place?
On the data, Again, you have to place your argument. You have to argue in their presence. Okay. And I also will not be able to keep mine. I am not got elephant memory and such. What can I do, Mr. Singh? I shall forget. You place your case on that point. 2 p.m. First 2 p.m. you will not get in August. August, not possible.
28 seconds.
28 seconds. Okay.
28th,
28 as second 2 p.m. matter.
obliged, your lordship.
Well, the record is required to be,
My lord.
Order is need to be passed.
Fine, sir.
Your lordship, one line order, your lordship.
Oh, all right. Why?
Kindly, your lordship.
Hard লিখে ওনার নাম লিখবে। You give your name, only your name. Only your name. ওই hard করে দিন। করে দিয়ে leave the matter for further consideration. আপনি ওই দিন
Ninth of July, this is tomorrow. I already informed Mr. Dotto, my lord.
Oh, tomorrow, so not today.
My lord.
Not today.
Yes.
139.
Well, I am for my lord to Respondent Distribution Company Limited.
Instead, take a contractor of West Bengal State Distribution Company and engage himself in Raghunathganj Division, Murshidabad. Since last 7-8 years, he has been functioning.
Termination order. Yes.
Job is related to my lord. Thing connection or emergency pure connection of the meter box, like that. This is the contractor. Last 7-8 years he has functioning. There is no dispute.
Yes.
Lastly, on 6th May 2024, 3 contracts have been given to him for 8 hours each for 24 hours service to provide electrical connection or repairing or emergency basis card, all electricity board. Now, what happened, my lord? There is a condition that I have to deposit the, my lord, provident fund amount, employees' contribution. Since last 7-8 years, there is no dispute. I entrusted a person for doing the job. What he done for 3 months or 4 months, he give me some false document. I have false document, forged document, admitted. I submitted my bill enclosing those documents. Then a show cause notice has been issued. If your lordship kindly take up, first your lordship kindly take up their opposition. The contract which I have been given, kindly see page 21 of the opposition. There are 3 contracts. Start from page 11 from the opposition. What type of job I have been provided? I have got annexed in my writ petition, page 11 of the opposition.
Page
11 of the opposition.
Yes.
Well, kindly see the first paragraph, suppliers, code number so and so, sub order for job contractor on purely temporary basis relating to so and so engagement. Then kindly see the second paragraph here, sir. The time is well at 1st April 2024 to 31st March 2025. Have you also got my lord? Last line of the second paragraph, left hand side. Page 11. There are 3 contracts I have placed before Lordship for 8 hours each for 24 hours. Page 11, page 21, and page 28, the three contracts. Page 21 is the second one, and page 28 is the third one. To provide service to the consumers. And particularly, then my lord, show cause notice has been issued. If Lordship kindly take up my writ petition. Kindly come to page 41.
Page
41. This is the show cause notice.
Yes.
The Lordship need not go through the entire first paragraph. Kindly read my lord second paragraph. These are the allegations. Page 41.
Yes.
Kindly see the date of letter, 7th of February 2025. This is very important. 7th February 2025. Second paragraph I am reading from page 41. Further, you have submitted the bills for the month of June 2024, September 2024, on 29th of November 2024, without any document of deposition of the Provident Fund contribution, Chalan, which is against the existing practice of West Bengal State Electricity Board Distribution Company Limited. Thus, the bills were returned back to the respective unit heads on so and so, respectively. On confirmation from the EPFO side, it was informed that the self-declared statutory documents of Provident Fund Deposition Chalan, which were submitted by you on 18 December and 20th December 2024, against the above mentioned bills, seems to be fabricated. But these are the charge. Your Lordship need not go through the entire document. Kindly see the date of documents, my Lord, 7th February. Now, Your Lordship, kindly turn back to page, my Lord, 35 of my writ petition. But admittedly, prior to that, my Lord, deposition has been made by me. There was a false information, but before issuance of the show cause notice, kindly see the date, 8th of January 2025. Third line, Chalan generated on 25th November 2024. Then, after some lines, wage month, June 2024. Have you also got my Lord, June 2024? 1, 2, 3, 4, 5, 6, 7th column, left hand side. Wage month, June 2024. At page 35.
Page 35 of
Writ petition. Sorry, madam. I'm
writ petition.
I'm sorry, extremely sorry. Writ petition. The Chalan issued by the Provident Fund Authority in respect of upper deposition of the employer of contribution.
Yes.
35, kindly see right hand side, 8th February 2025, 8th January. And show cause I have shown to your Lordship 7th February 2025. So prior to show cause, actually money has been deposited. Although there is a wrong information, kindly turn my left page. 35, Chalan generated on 25th November by the authority. Then wage month after 5th, 6th line, June 2024. This is for June 2024. Kindly come to the bottom portion. Payment date 8 January 2025. Payment confirmed date 8 January 2025. So for June is concerned, I have deposited the money on 8th of January. There is no dispute. Next page, kindly turn up, my lord. So for the July is concerned, kindly see 8th of January. But charge is that on 7th February 2025, you have not deposited the money. Wage month, July, 8th January. Then, my lord, August, 8th January. These are also under the charge. And other 2 months I have given in my month of February, that is page 38 and 39. The dispute is in respect of these 5 bills, rather the chalans. Now, what happened, my lord, after filing the writ petition? Prior to that, my lord, if you will kindly turn to page, my lord, 50. After show cause notice, I give the detailed reply saying, kindly turn to page 43, my reply. At 12th February 2025, I have given the reply. Last paragraph I am reading from page 43. Unfortunately, my bills for the aforementioned jobs submitted from May 2024 to nominate remain unpaid. This is one of the count, leaving me in severe financial crisis. Despite remuneration, however, due to second page, my lord, page 44, second paragraph. However, due to negligence and maintainable mistakes, some chalans, especially payments of September, October, and November, were incorrectly submitted. I assure you this was not delivered attempt, so and so. After considering my reply, ultimately my contract has been terminated. If you will kindly turn to last page of my writ petition at page 5G. On 11th of March 2025, my 3 contracts have been terminated, which will appear from page 50. On 11th of March.
Page
50, last annexure, last document of my reputation. Termination letter.
Yes.
Now, what happened, my lord? Without calling for any tender, they have given my contract to somebody else. If you want to kindly turn up the opposition, page 112, 113, and 114. The job has been provided to somebody else without any tender. Now, today, possibly, my lord, since these gentlemen, 3 companies who have been engaged, since they have not made party, I cannot say, my lord, their contract will be terminated. Today, my simple pair, my lord, huge amount of due. Since I have filed the writ petition, they have withheld entire amount. So far, the other bills are concerned. The issue is that you have filed the writ petition against the corporation, distribution company. We are not going to payment. Today, I am paying before your lordship. Only thing is that my dues should be paid within a certain time. So far, other jobs are concerned. And in the future, because I have not been blacklisted, in the future, my candidature shall also be considered along with others. Because I have not been blacklisted, only termination. I am entitled to do the job. These are my only prayer today. What will I learn will not oppose this prayer?
You pay the dues.
My instruction only in each and every amount has been paid, but that is not the scope of the writ petition. No prayer has been made. If we document, my lord, if the prayer is made, that can be considered, my lord. But one aspect of the matter. But my lord, the conduct.
Payment has already been made.
Yes, my instruction is payment has been made. No dues is there, my lord. Even if, my lord, if anything is due and payable, my lord, then my learned senior friends client will make an application with document that can be considered. But that is not within that can. But my lord, that is not within the scope of the writ petition. That is not even appropriate for. Now, my lord, only one thing, my lord, is the conduct of the party, my lord. Now, my lord, my learned senior friend, my lord, has produced. Lordships kindly come.
আমি তো মেয়েটা কিছু বলছি না।
Now, my lord, lordships kindly come. The receipt. That is at page 35 of writ petition. My learned senior friend has produced it.
Yes.
Payment was made on 8 January 25. My lord, last but 3 columns. Payment date 8 January 25. Payment confirmation date 8 January 25. Generated on 8 January 25. But that is not the fact. Lordships kindly come to the show cause. What they produce, Lordships kindly come to page 95 of my opinion opposition.
Yes.
95. That is something which was given to us in respect of something where my lord payment date, last but 3 column, 9 December 24. Payment confirmation date 9 December 24. Now, page 94, we have written to the EPFO authority, kindly confirm whether the payment, statutory payment have been made or not. That is page 94. Enclosing the documents which have been provided by the petitioner to the distribution company. Have you lordship got? Now, this is in respect of something in respect of which payment was made on 9 December 24 that they produced. Now, lordship kindly come to page 101.
Yes.
Non-availability of TRRN details of EPFO portal, your office number such and such. This is reference to your letter under reference regarding the subject matter in the context. This is to inform you that the queries pertaining to TRRN mentioned in your letter dated such and such, date 30th December 24, concerning Messrs. SI Electrical bearing such and such PF code are not available in TRR query search. That means documents that have been produced before the distribution company in order to maintain that we are complying the statutory formalities are forged. When we have indicated, we have focused for producing false document. Now they have made payment on 8 January 25 and said, yes, it is payment is already made. So it is not that payment was already made, but mistakenly some other document of it. This is not the fact. That apart, but I have enclosed several representation of their employees to us as well as the labor commissioner, wherein we are made parties that we are not being paid salaries, we are not being paid the statutory, they are not complying the statutory obligations. Now we have questioned them, no reply has been given. That is why, my lord, if your lordships kindly come, since my learned senior friend is not pressing this point for the time, but for the effective adjudication, my lord, it is required, my lord, lordships kindly come to page 58.
58 of
my opinion opposition.
your opposition.
My lord, starting from 54, this is an office order also. Starting from page 54.
Yes.
Office order 17, my lord, kindly skip over for few pages, my lord, 58. Last 7.8. All statutory obligations and terms and conditions incorporated in this order are to be strictly complied with by the agency. In case any deviation, non-compliance is notified, the controlling officer will take necessary administrative measure immediately. For repeated failures, within bracket, after 3 such occasions, the agency may be terminated without any further reference, and enlistment may also be cancelled. May also be cancelled. Now, if you will also kindly come to order of termination that my learned friend has produced, my lord. Page 50. For 50 of the writ petition.
Yes. Yes.
Now, my lord, reference has been made. My lord, as many 3 times, my lord, opportunities were given. My lord, even then, my lord, they did not rectify themselves, my lord. My lord, termination followed. That apart, my lord, this contract was valid up to 31st December 2024, 31st March 2024. So after 31st March 2024, my lord, duly, my lord, we have engaged, my lord, very emergency service, my lord, duly we have 2025, I stand corrected, my lord. After that, my lord, we have given, my lord, to somebody else, my lord, I have given the name of it. Now, my lord, even then, my lord, my learned friend is at liberty, my lord, to challenge, my lord, the procedural part, my lord. Even that is not under challenge. But that is, even, my lord, that cannot be, my lord, agitated in this writ petition. Only what is left, my lord, if any amount is my record, my submission, entire amount has been paid. If something is left, according to the writ petitioner, they may make representation, my lord, detailing, my lord, every aspect of the matter for which, my lord, it is, according to them, it is due and payable, we can consider.
So whether his enlistment has been cancelled.
Enlistment, my lord,
No.
I have, my lord, that is
your
not,
termination does not indicate that he will be disqualified.
No,
in
not
participating
indicated.
in future.
Not indicated, my lord, not indicated, but
So-
my lord, my lord,
So I am recording that.
7.8, 7.8, my lord, indicates that, my lord, I'm sorry, my lord.
There is a provision, I do admit, my lord, but they have not done it.
Page 58.
Their opposition, they have not made out that case also. Only termination.
At page
So
59
for 3
also,
jobs are concerned.
enlistment may also be cancelled.
That has not been done.
In the event, my lord, if it is not cancelled, my lord, I believe, my lord, had it been, my lord, it would have been duly communicated to them, my lord. Lordships kindly indicate, my lord, if it is not cancelled, in that event, my lord, they can participate, my lord. But
if
no,
if not at all,
says
it
decided.
has not been cancelled.
If
You
not,
cannot punish any person twice.
now, if, my lord, that is under, my lord.
Once you will,
after
you
3
will
times.
terminate contract. After a few days, you will
Termination, my lord.
cancel his
Termination was done, my lord, 2 days prior to, my lord, the statutory, my lord, contractual period is over. 2 days prior to that. It was terminated on 28th March. Contract was up to 31st March.
Okay.
Kindly see only one line. Page 59. My learned friend shows last 2 lines of the page 58. Kindly come to page 59 of their opposition. When termination does, when my lord, blacklisting does come, for repeated failure, page 59, top.
Yes.
For repeated failure after 3 such occasions, now this is the first occasion.
Agency may be terminated without any further reference, and enlistment may also be cancelled.
So, my lord, for repeated failure after 3 such occasions, this is the first occasion. There is
No. But that is referred to in my letter also.
Not intimated. এটা হলো 3টে জবের রেফারেন্স। These are the reference of job. 3 jobs, page 50. Only show cause notice, kindly see 1. Your reply, intimation letter at so and so, then 3 jobs have been described.
Let's basically make it clear, my lord. If a decision is taken, my lord, so far blacklisted, my lord, I'm with my learned senior friend, my lord.
What kind of
If it is done without any opportunity hearing, my lord, that can be also subject to further writ petition. But my lord, lordships kindly indicate, my lord, if any
That is
decision
not their affidavit. The court will proceed on the basis of the document. He has filed an opposition, never saying that it has been blacklisted.
No, blacklisted, my lord, there is no provision itself, my lord, for termination, my lord. In that, but for my learned senior friend is absolutely right. They have been, my lord, continuing for last 8 years, but my lord, not with repute, not with. I have not placed, my lord. I have annexed with the opposition, my lord, all the complaints, my lord, that have been lodged, my lord, before the West Bengal State Electricity Distribution Authority, my lord, as well as Labour Commissioner, stating that they have violated the statutory provision. Labour Commissioner, my lord, hold a joint meeting.
No, they are not depositing what? Their contribution towards a provident fund of the employers contribution.
That I have done.
Salaries
But
also.
some forged document I to admit, my lord.
Okay.
The person concerned who has been entrusted the job, he has done it. Subsequently, entire money has been deposited. That is not their case also. I have not deposited.
No, lordship,
I have
comes to page 83.
83.
He is not showing 83, my lord.
'83 onwards, my lord, I have enclosed, my lord, document, my lord. They were so cost for
Yes, only for this purpose.
Payment of wages.
So far, these three jobs are concerned, not in respect of previous any occasion.
Okay, the patent petition has been preferred, challenging the legality of the
put it day after on the same position.
I know that motion or
But this issue is already decided by this honorable court in other judgments and which is affirmed by the honorable division. Your
আজকে
lordship
তো
will take
ধরাই
only-
হলো না এবার কালকে কালকেও তো আপডেটটা দিতে হবে আমি তো ধরতে পারবো না কালকে কটা মোশন আছে Okay, I am thinking whether what can be done. Today, after motion, upgraded matter was given at the top of the list.
I just have a
Upgradation টাই রাখুন। If it is upgraded matter is retained in its position, send a junior who will pay for accommodation on your
just pray for accommodation, my lord. Lordship, the matter will go to the bottom. This is what I was apprehending. I have my personal difficulty tomorrow only, my lord. This is why I just pray. My learned senior friend for the other side, one, he is just standing outside of the courtroom. He says that he has got a headache and doesn't want to.
Tomorrow also he will suffer from headache.
He doesn't want to do this
Oh,
today.
today he is suffering from headache. Tomorrow also he will suffer.
Tomorrow it
Eh? Since tomorrow Mr. Roy has engagement in other tribunal or anything like that.
No, no,
Tomorrow,
my personal business. my lord.
tomorrow also Mr. Sachansar. তাহলে এটা একটু মনে করে দিবেন। এটা আপনি 13টা ইয়ে করে রাখুন। ঠিক আছে? মেনশন।
But he's there. My learned senior friend is there. So এটাকে আমি day after করি না।
ডে আফটার tomorrow করিয়ে দিন। কিভাবে করবেন? কাউকে কি রিটার্নেবল কিন্তু আজকে তো অ্যাকচুয়ালি ডে আফটার tomorrow এটা ঠিক আছে? Okay, you come. Okay, I succeed.
Writ petition on behalf of DVC. Now,
On behalf of?
Damodar Valley Corporation.
Ah.
And also the difficulty is we don't have any documents. Now we have applied for certified copy of all pleadings, but since the file is in the courtroom, the department is not being able to provide us with a certified copy.
The matter stand released from my list.
If your lordship kindly,
That would be
no,
proper.
not release, if your lordship kindly directs the file to go to the department for a day or two so that I can take steps for obtaining the certified copies. That's the only
As paid for on behalf of the petitioner matters stand released from my list.
64. Not with liberty to mention it after getting certified copy, your lordship. Otherwise, I will
Matter go out of list with liberty to go out of list. Stop liberty to mention.
And if the file can be 64.
Okay, that's all.
And it is.